Out there. On something. Oh, wait. Yes.
Damon, no,
Like right after the three.
yeah.
Yeah. I haven't found one, but I did. Oh, yeah.
So this is Mike Newmark with the PSC. I'm just checking in with people joining us on Zoom. Looks like we have a phone number ending in 447. Can you just identify yourself? If you're connected with a party, let me know who you're affiliated with. You need to press *6 to unmute. If you're a member of the public, I'd recommend that you watch the hearing on our YouTube channel. If you don't have an adequate internet connection, you can continue to listen over the phone. But if you could unmute and let me know. I need to press *6.
Hi.
Yes.
Hi, can you hear me?
Yes.
Hi, this is Patricia McElroy. I'm from town of Eagle Point in Chippewa Falls.
Okay. And so are you a member of the public? You're not connected with the utility?
No, I'm a member of the public, and I'm having a hard time getting into the Zoom part, so I may stay by phone if that's okay.
Yeah, sure, that's fine. Just listening in, I'll just stay muted.
Okay, thank you.
Yeah, because my phone sort of automatically. That'll change.
Okay. WD-40. Who is the squeaky chair?
Wait, all of us apparently.
Oil.
No, I just said we need some WD-40.
Richard Clayton or
Okay.
Brian.
Yeah, mine is super.
Do you want us to switch out?
There we go.
If you can find one, yeah, I mean, I just don't lean back.
Don't move when you're putting there.
It's, yeah, this is a.
This one.
That was the worst. This one has
One.
high pitch.
That's.
This was the best.
We had a hearing where the noise was obliterating words for me.
Yeah, it's.
Like, if they- somebody was
This is the
talking-
first squeaky chair incident.
It's better.
I'll just sit very still.
Yeah, there you go.
As long as Brian is happy, I'm happy.
Did you get one too? Oh, you smell a little sweet.
A little, but I don't be back in. Yeah. I don't know what that.
Yeah, these ones are good.
It becomes problematic.
Anyone recognize Tracy Holloway as part of the?
Yeah, she's a witness.
The witness list. Used to, I gotta figure out which case I'm on right now. Few more minutes here, letting people join us. Yeah. Good. Good. It says Mike Newmark with PSC. It looks like we have a screen name person has joined us with the name MPL Ottertail. So if you could show yourself and unmute and let me know who you are. Okay, see you there. Who do we have in that connection? Oh, you got 3 cameras. Great.
Yeah, this is Josh Gusman from Excel.
Oh, you're from Excel. Okay, so do you have a witness then that's connected? That'll need to appear? Or are you guys just observing?
It'll
Josh.
change more.
Josh Gusman.
Gosh.
Okay, so I think possibly since you have so many cameras there, you may have sounds like you have a little bit of an echo there, so we can adjust that, maybe just give us one camera and one microphone. But I'll let you work that out. We'll proceed until I witness this to you. Okay, so I just admitted Amelia Boss to the party session. Can you just identify who you're affiliated with?
Yes, Your Honor. Amelia Voss with the Clean Energy Organization.
This time it's the people coming, right?
Any other attorneys out there?
Yes, Jeffrey Small and his colleague Max Meyer. Oh, I think that is Abigail Henchek, attorney with CEO. Oh, no, that, Amelia Voss, I think she's the attorney CEO.
What's the last name?
BOAG.
Yeah, well, if I could just.
And there may be an attorney with. There's the Excel function, I'm not sure. See what one of that is. Well, we're a minute late. Doesn't look like there's anyone joining us anymore on Zoom. So let's get started here. We'll get on the record. Welcome, everyone. This is Docket 5 CE 158. The party session and the docket we've been calling the Western Wisconsin Transmission Connection Project. This is Michael Newmark, Administrative Law Judge for the PSC. We're here in Madison in the PSC hearing room. also on Zoom, where we have our some witnesses have been connected by Zoom. Let's start off with appearances. So we will check with service list first and go through that in alphabetical order, starting with ATC.
Brian Potts and David Zappo on behalf of American Transmission Company.
So just off the record. So just maybe you're a little rusty in this hearing room. If you want to speak, you want to make sure that green light's on your mic. So
It is on.
It is.
Maybe move
Just
closer.
tap it a little, maybe.
I could hear you,
Okay,
but
can.
Okay,
when
just
you're,
move it closer.
It sounded different than I'm
That's
used
why
to.
I looked at it. And
Yeah, and I noticed that, so there we go. Okay, so we got ATC now. Okay, we're getting through this. Okay, back on the record with Chippewa Valley Preservation Alliance.
Yes, CVPA appears by Attorney Eric Olson of Eminent Domain Services LLC.
Citizens Utility Board.
Good morning, Daniel Marby, Citizen Utility Board, also present is Corey Singletary.
City of Altoona. That wasn't the caller, right? That was a different municipality I thought. What's that? Let's call it the record. Sure. I'm never there anymore. Okay, well, we'll get back on. So we did have a municipality did connect earlier by phone, and I'm 99% sure it wasn't City of Altoona, but I can't say for certain. They're not there anymore. No one's connected by phone anymore. So so just to note that, hopefully they'll join us if they wish. Clean Energy Organization.
Morning, Your Honor. This is Elizabeth Wheeler with the Clean Energy Organizations, and I'm joined by Zoom by Amelia Voss and Abby Lodge.
Clean Wisconsin.
Good morning, Your Honor. Katie Nicole with Plain, Wisconsin.
Maryland Power Co-op.
Rob Malley, appearing on behalf of Carolina Power Cooperative.
All right, thanks, and you're welcome to sit if you want. It's there's an extra seat, so you can if you want to sit down there, okay? MISO.
Richard Heineman, Your Honor, and also appearing by Zoom, we have Jeffrey Small, Maxmeyer.
Okay. NSPW.
Good morning, Your Honor. Lisa Monty on behalf of Axel Energy.
Public Service Commission.
Sophia Rogers.
Make sure I'm getting everyone here. Renew Wisconsin.
Morning, Your Honor, Sharif Halawish on behalf.
I'm sorry,
Sharif Halawish on behalf of Renew.
okay, sorry.
Okay. And we.
Yes, good morning, Your Honor. Steve Heinzen on behalf of WEG.
Okay, all right. So I guess before we move on, can I ask you, Attorney Heinzen, why aren't you not at the hearing room?
I apologize for not being in person. I certainly can be there later this morning on a break.
Okay, yeah, and now I got my recollection refreshed before the hearing, and I believe there was a requirement for attorneys to be present, at least one attorney for each party to be present in the hearing room. If you, well, I guess if you're participating at all, I suppose we don't have City of Altoona, but
right. My apologies. I will be able to be in the hearing room later this morning.
Okay. All right, appreciate that. Okay, so we got our appearances done. So let me say for anyone who may be listening in, we're live streaming the hearing, and did want to mention that today is the party hearing session, so we're taking evidence from the parties and commission staff, and those witnesses are subject to cross-examination. We held the public hearing session on July 23rd and July 24th. First day was in Eau Claire, second day was in Holcomb. So we took public comments there, and we also received written public comments Those comments were due July 26th. So we will have a public comment exhibit that will receive for the record the written comments that we've collected as part of that process. So all of the, and the comments that are subject to that process are the ones that we receive from the date of the notice of hearing, the date it was issued, June 12th, until the deadline, July 26th. So I did share with parties and commission staff the offered evidence list, and we did have a few preliminary items we need to discuss before we move forward, but probably want to take the more substantive issues first. I think the one that rises to the top is the motion that's pending. We have some notes on that. So it looked like if I can get the procedural history right here, there was a direct filed by CVPA witness. Is it Marek?
It is, Your Honor, Marek, yeah.
Witness Marek filed that direct and exhibit, the one that issues is exhibit 2. That was there was a request to strike a paragraph in that direct and exhibit 2. Then that the request triggered a response period, which the CVPA failed to respond in a timely manner. So I issued by email an order that granted the motion to strike due to the lack of a response, failure to respond. And the CVPA had complied with that order by filing the active version of direct. Subsequent to that, I received request to reconsider that order. The CVPA claimed that they did not receive service by email of the request. Therefore, I should reconsider this because CVPA did not have an opportunity to respond on time. The applicants, and I don't think I mentioned this issue was brought up by the applicants. So then the applicants replied to the CVPA request for reconsideration by stating that the document was filed on Earth and therefore the requirements for notice to CVPA were satisfied. So that the triggering the process by which I could rule on a request based on a non-response is valid. So at this point, I guess we can hear a little bit more on this. I think I do have a bit of a concern about how this has been teed up, and I need some clarification. So I can ask CVPA first off if you have anything you'd like to add based on what we've heard from on the reply from the app.
I think they also didn't serve their reply other than just filing it on the ERB. So I don't know what to say about the whole thing other than that.
Can you give me anything substantive about the response about that? Is there anything you want to add?
Substantive to the motion itself. I don't know
the process of not.
So the process, it's that if there is in fact a requirement of serving motions and responses and things of that nature by email, they're not doing it. And if that is just a formality and it doesn't exist, then, you know, we didn't do a good enough job, you know, sitting on top of the docket. It's probably a situation where, quite frankly, both sides maybe could have paid a little bit more attention to detail. You know, when you get right down to it, I hardly think that this, quite frankly, is going to be the issue that this whole thing rises and falls on, which is the admissibility of EIS from the 1990s. But I do think that it has some probative value, and I don't know why the commission, quite frankly, would want to deprive itself of any relevant information, no matter how attenuated that probative value may be. This is a EIS that was created in conjunction with a public project. And I think, if anything, probably the appropriate course of action would be to reduce it to just the probative pages and give us some amount of time to submit a reduced exhibit to Mark.
Okay, so let the applicants respond. Any clarification you can give me as to the interpretation the applicants have on the facilitating matters order that allows service, but not, that allows filing to somehow constitute service of the document and meet that service requirement?
LJ York, we relied on the statement in the FMO that we put in our reply that filing equals service. So we thought we had properly served the motion. And wanted to be more efficient at hearing the other possibilities, cross-examining the witness on his lack of foundation and the staleness of the document. So we can go either way. We just don't think it's appropriate in this case, given its age and the lack of the ability of the witness to be able to testify to it from personal knowledge.
Okay, so so I'm not gonna, I can't really go either way with this, because I've never seen a situation where this has been confused, and there is an attempt in the process to revise the FMO, but with all the work that we did to revise it and make it more clear, this didn't seem to need to change because I've never seen this situation come up. It kind of boggles my mind. So I took it out of context, but we can go to the document itself if we need to. But if you look at the FMO section C, point 2, it deals with filing requests for ALJ order. And yes, it says file the request unless timely made at a hearing. But FMO section B1F states filing constitutes certification of service. That to me, I don't know what situations that would equal service. Filing does not equal service. It means to make things a little more streamlined. If you file, you're certifying that you've served. So you serve and then you file. And if you look at the citation we have in the FMO, it says C, list admin code, section PSC 2.06, sub 3, sub A, which states the filing of any paper required to be served constitutes a certification by the person making the filing that a copy of such paper has been served. I just don't know why we got confused about that. So I'm denying or reconsidering the motion to deny, to strike the portions of the Marek testimony and Marek 2, and not denying that motion based on failure to serve, and therefore the basics that I have for granting the motion, which was failure to respond to the motion, is invalid. However, I appreciate Attorney Olson's offer to perhaps trim down the EIS document. Something that's been filed in 2 parts because it was too big to file in 1 part, which always makes me nervous about how big a document could be. And if there are probative parts that CVPA wants to draw the commission's attention to, it's best that we just include those pages. So you would want to sort of properly file that. It would be exhibit Marek 2R, and there would be a cover page and then a title page, the title page of the document itself, and then following that, the remaining pages that you wish to offer for the record. That'll help just cull the document so we can draw attention to the proper point. Allowing sort of, I guess you can call it a voir dire to get the witnesses connection to the document or qualifications to speak on the document.
that's fine. We put that in the record. The commission can review that in terms of how much weight it wants to give this document. So you can ask where it came from, how you got it, what's your connection, what's your expertise to be referring to it. I think he's just basically quoting it, but we do allow this type of document into the record as a matter of practice. To the extent I think it's probative to a degree, but the fact that it's stale is something that applicants can pursue. The fact that it may, well, I guess let's leave it at that. That also can be put on the record for the commission to weigh to give the document weight. So I hope we can move on from this and all learn from it. I guess I can add something else if we want to be more clear on the new FMO. If that ever does get used. So we will do our best to follow and understand these rules. Okay, so do we have, so I can give you 3 days, our normal 3 working day deadline to refile. And so the statement in the direct will remain. So looked like Mark did file a revised version of the direct. But I'm gonna receive the original, just so you know. So any questions about that? So let's move on to just a couple of tips here. I wanted people to know, because I think we will be seeing you guys repeating your appearance in future dockets. So I did note that we had a naming of the application or miscitation of the application exhibit. So please review the FMO to properly cite to that. Did not require refiling at this point, but it's nice to see that done correctly. We had Cercer rebuttal served, and I'm sorry, we had Cercer rebuttal filed on her. Did parties receive that from the applicants then by email? Yes. Okay.
Yes. Thank you.
We have two different Cercers. NFP had Cercer and we had Cercer and we did a different one. Yes, okay, so yeah, thanks for pointing that out. So we did have Cercer from NSPW that was filed. Was that served to parties?
Yeah. Yes, we received it.
Yes.
Okay. So so in the future, the way the FMO is structured, you don't need to file Cercer because it's not part of the process in terms of the letter of the law. There's no filing time frame for that. So what the FMO says, if you want to bring a document to the hearing, you need to email it to the parties so they have it in hand. That's mostly because we do these hearings as a hybrid at least, and we won't be able to hand the person, say a witness who's on Zoom, the document. So but it hasn't been received yet, and there may be changes that need to be made, so just email it, just serve it, and then once it's received, it gets filed. So that's just a future note. Then we had some misnaming and issues with the CEO documents. So just please review the filing requirements and the naming requirements so that we're all citing to the document properly. And I don't have to fix it. So and I think the final sort of preliminary item is that so we went through the pre-hearing process, and in the notice pre-hearing conference, I identified the applicants as having party identifiers, which we use for citation and naming documents. And And so in the notice was an offer that ATC use the identifier ATC, NSP use the identifier NSPW. And then upon reading the filings, they combined into using the same identifier applicants, which may make sense and may be useful. However, if we're telling all the parties to do it this way, where we have two different identifiers, there may be a lot of confusion with that, people filing wrong or in different ways. So we all want to get on the same page. So I'd appreciate if parties do wish to propose a different party identifier, they do so at the pre-hearing, or when they're if we don't have a pre-hearing, if there's a meet and confer between staff and parties, that they should ask for something different, because we all want to be on the same page. And so trying to make this process go easy and more efficient, but it seems like as soon as we do that, we create another issue. So go ahead.
I just have a question. So a lot of the documents are like filed by both of us. So for example, the application exhibit says exhibit applicants. So should that say exhibit ATC NSPW and then application? Because there's two, I don't know how to put two parties in a naming convention basically.
So I'm sorry, let's go off the record for a second. So I don't want to get upset, but I did answer that question already in this document. So I said, although this designation is unauthorized, I'm not inclined to order ATC and NSPW to correct all their filings to comport with the PCM. In the future, the process would benefit from a discussion about the party identifier at the PHC pre-hearing conference, or a request to change it after the identifier is ordered. So people could please read what I'm giving you.
I did, Your Honor. My question is, if it's like this, how would we file? I'm not saying we're gonna go refile everything. I'm just curious how we would identify in that situation a document that's filed by two parties. Is that dealt with in the FMO?
No.
Okay,
No,
so we
you
would
would have to bring it up at the pre-hearing.
So if we think there's gonna be any
Right,
filings, then we
exactly.
would bring it up to bring
Bring it up,
Okay.
or or file something that you want to correct it.
Okay,
Okay, so if this gets issued without a pre-hearing conference, and then you say, well, we could file, this needs to be filed in joint, then propose a change.
I see. Okay.
Okay, that's what it says. Okay. All right. So perhaps it's best to see if we can excuse witnesses, or also excuse witnesses that have no cross now, and then we can go into more of the details of the filings. So we can do this off the record. It sounds like CVPA had questions for all the applicant witnesses. Is that still the case?
No, I think we can pare that down a little bit. We need to ask some questions to. Is it Ashman? Ashman, Ashman, Christensen. Feltus, thank you. And that may be the extent of it.
Okay. And as far as the emails that we received, no one else had questions for other witnesses. Did I get that right? Is there any change to that?
Well, Your Honor, I think staff has one question for the minor witness.
Right, okay, yeah. So
I'm
that's-
sorry, can you repeat the question?
So any other witnesses that have cross questions? So we have cross questions for, so Donna was one.
Yes,
Commission staff had questions for Blauser. Yeah.
Blauser, and you're crossing Wendland already. We're crossing Wendland, no longer need to cross Christensen, Wendland, Blauser. Connor. That's it.
Okay. I have other.
I'm sorry, Goodsman.
So I don't know if we have to call these witnesses, but I did have issues with, some of the testimony and their combined nature with like this docket and the grid forward docket, and I mentioned that in my, in the comments to this, to the offered evidence list. Perhaps we can just get on the record and deal with this through the attorneys and see if we can come to some sort of understanding about this, or at least give me a reason. So let's get on the record for this. So, okay. So I just want to review, before we excuse our witnesses, there's a variety of filings that present evidence with respect to the grid forward docket, which is 05 CE 157. And I flagged the portions of testimony that appeared to just be too specific about grid forward in this case as being relevant evidence. So I just wanted to get people's opinions on that, and see if there's either a opportunity to change testimony in that regard, or perhaps just identify if a witness is speaking globally about both projects, that they identify to what extent this applies to this project, and to be specific about it, be specific about this project rather than talking about both. Now, it looked like some witnesses, just the information they had was combined and they probably cannot do that separation, but I wanted to check with everyone about that. So just starting with the applicant, I think, is it Oran? When this Oran was talking about the PVRR of both projects, but there's particular passages that deal directly with grid forward. So I just want to know if that's necessary in this case to have the PVRR calculations for grid forward in this docket, strip that out of this one.
Your Honor, at the beginning of this case in our application, we noted that each project is independently needed and were evaluated both individually and jointly. And so when you're talking about the joint benefits of the project, we have to have the PVRRs of both projects. I think at this, given how the case has been set up and this late juncture, I would not want to be tinkering with testimony and trying to excise various pieces, because I don't know that there is anything that wouldn't be relevant because of the interrelationship of the two projects.
Okay. But should the commission only approve one project, not the other? Is there evidence that provides them the benefits of this one project?
Yes, Your Honor, the case we've made is that the project is needed individually and has synergistic benefits with LRTP 6, which is in docket 157.
Okay. Okay, well, I mean, I think it is late in the process, so I do recognize that. I think if I had been able to review direct earlier on, I would have made a stronger push to excise facts about grid forward in this case that are just specific to grid forward. But I'm not going to do that now. So There are a few filings, I think, just in terms of formatting that we don't want to double docket. Put both dockets in a filing, so the filings in this docket should only have the docket title for this C 158 on it, so we need to refile and strip out the C 157. So I think that same argument holds. I think there's some issues with, same issue with Singletary's testimony, but we'll just leave it.
Your Honor, I might be able to clarify something too that would help, because we're gonna have another hearing in a couple of weeks with the same issue. So the need analysis for these projects is done together, and the PVRR for each is needed in both dockets to calculate the net benefits of the projects together, which is evidence in both dockets. So we actually do need the evidence of the PVRR of each one in both dockets. Because among other things, the commission staff has asked us to look at them individually and together. So that's just as background.
Thanks, I appreciate that. All right, let's go off the record.
Sorry about that. That should have been. I'll want you to read. Perfect.
Okay, so like I mentioned, the Singletary, the similar situation, we'll just leave it as is. Godwin as well. Gallagher. And I believe, I didn't even note that for the MISO testimony, because I think they're just speaking about the total review of the LRTP project, so. I was not gonna assume that it was gonna be separated out, so. So let's see, so at this point, I think we can excuse everyone, all witnesses except for Ashman, Christensen, Glauser, Gutzman, Wendland. I think Mark, we're gonna have some questions for still, or been done.
Yes, I'll become the vitals for Mr. Ladner.
Mark. So we're not excusing Mark. Not excusing Donner or Feltus. So it looks like all other witnesses are excused and they can file a verification affidavit and need not appear. It's up to the applicant, to the party or commission staff to call those people if they wish. They still have an opportunity to add testimony on the stand, like as provided in the FMO. But as far as I'm concerned, I can receive their written filing by affidavit and they need not appear. So is that clear? Yeah.
Your Honor, if we could verify Dr. Gallagher on the stand, I'd appreciate that.
So it's up to you to call that person if you'd like.
Okay, Wisconsin calls Dr. Gallagher.
Not yet.
Oh.
No, I didn't realize you were going there. No, we're not ready.
Okay.
With Mr. Burmester, he had some sir, does he need to, or is that a different situation?
I think that is, yeah, I think, yes, thanks for mentioning that. Yeah, we'll need to have that person verify. Well. Sure, let's do it. Let's make it here. I don't know, I mean, if there's, if people have received that document, there's no questions about Burmaster or rebuttal. Is that the case? No questions. Yeah, I think that's fine. We file that and include it in the affidavit. It needs to go to. Okay.
Your Honor, may I bring something up?
Yeah, on the record, yes.
I don't know that it needs to necessarily.
Okay, get off the record.
I was just wondering, Mr. Mark is broadly available, I'm sorry, Mr. Mark is broadly available throughout the whole time by Zoom with a little bit of notice. I was just wondering if it looks like things might be moving a lot faster than I had sort of anticipated. If we could sort of loosely schedule a time for him, or else just agree to do him first thing tomorrow. And then I would investigate either having him here or having him totally ready to go first thing tomorrow. I don't know if that would be.
How much notice do you think you need?
I mean, at a minimum, maybe 15 minutes, but ideally a couple hours.
Okay, so if just to appear on Zoom,
Yeah.
a couple hours or less?
Oh, I mean, it could be as little as 5 minutes. He's supposed to be standing by all day. You just never know if people.
My guess is we're gonna do this today and we'll be done by today. So,
What would be a good time?
we can see how it goes. I mean, I don't wanna,
Maybe first thing after lunch.
yeah, for even. Sure, let's do. Let's set him for, yeah, okay, let's set him for noon, 12:30. We'll see if we hit that mark. If we don't, we'll have to readjust.
Your Honor, sorry, we're talking about scheduling, at this point. We did have a request to schedule Donner's appearance.
Okay.
So I just don't want to lose sight of it. I don't know when you were planning to address that, just in case.
I did not, I kind of forgot all about that, but it's true. What was the time you forgot for that?
Your Honor, this is Jeff Small. We did make a request and which was granted, of course. But I wanted to point out that although we made that request, Mr. Donor is available and immediately if you like. So we'll withdraw that request and you can put Mr. Donor on this morning if that is efficient.
Okay, so I mean, our typical process is to go through the applicant witnesses first. So I would expect not to see that happen for a while. So what was the time that you were interested in, just so I know?
Not earlier than 12 p.m. So that's,
Okay.
yeah, so
The afternoon, that's fine.
Yeah,
We'll be able to do.
shortly after lunch, you know.
Sure. Any other requests for timing I may have missed? And I know you sent it in, but I may have overlooked it or forgot. No?
There was, commission staff, witness Will Cobell, has a 4:30 cutoff request today and a 3:30 for tomorrow, and then, Paul Ron has unavailability tomorrow morning.
Well, we're not, and you're expecting to call them.
To verify, we could always do that payment, you're right. For both of them, we could do that.
And Ron was what time then for today?
Today, anytime, tomorrow, he's out in the morning.
Okay. Maybe just let's move forward here. Any questions about the comments?
You're still on.
Yeah, we're on.
I have two quick things.
Okay.
One, our witness Holloway, who has now been excused, is on vacation this week, and is there any way she could file her affidavit early next week?
Yeah.
The 3-day window.
That's fine.
Okay, I just wanted to make that clear. And then I don't know if we're taking, if you're ready to take comments on the offered evidence list, or you can do that separately, but I did have one comment. Hodgson's testimony rebuttal is under Holloway, should be upline. And then I think you added it already, but also Burmester Sir wasn't on it. Yeah, okay, those were my only comments.
Well, okay, so let's just handle, just want to welcome our commissioner to the hearing. Thanks for coming. And just go over the comments to the offered evidence list. Any questions about that? Look like ATC had a few. No? Nothing? I did want to note just to thank the applicants for coming up with their new application exhibit. I think it actually works really well. And if we could use that format, and to be honest with you, the biggest thing is that you checked where the CII is indicated. So then I'm hoping that means I don't have to actually create a link, which is a lot of work in the back end to create that link to our super secret repository. So it's just going to tell the commissioners there is CII on this document, and then they can go find it. And that's great. So if you guys can use that format from now on, I think that really solves a lot of problems. I did note that I guess you're calling the application document itself the narrative. And I don't know what I think about that. But I've just called it the application in chief. I don't know if that makes a difference really, but in terms of citation, we're just gonna stick to the regular way of citing it. So it's not, I wouldn't use narrative in the citation. Comments here.
Your Honor, I'll just note that we did file revised SIR for Ms. Ashman, so that her number would be updated if it needed.
Oh, okay. So there's a new version of the SIR rebuttal.
Yes, Your Honor.
And let me get that. You wouldn't have to have the PSC reference number. Then.
Your Honor, we did not file it per your.
You did not file. Okay, that's fine. So do I have a copy? Has a copy been sent to me?
Yes, Your Honor, you're included on the email yesterday.
Yesterday, so. Not seeing that one. Any idea around what time that might have been sent?
I have it 12:57.
That says it's revised, and then there's a -C. That's not confidential, is it?
No, Your Honor, I think it ended up being a copy on my desktop. I apologize.
Okay. Nope, no worries. So we just refile that or file that when it's time. Was there a substantial change made or just a practical?
Your Honor, there was an acceptance of the revegetation condition as opposed to opposing it, so it was a substantive change.
Okay. Okay, so any questions about the offered evidence comments? Any corrections we need to make besides the ones we've already heard, the corrections to the document? Did I?
Your Honor, I did note that you had made one comment on the CEO's exhibits 9.1 and 9.2, and I will say we are willing to revise those to a smaller exhibit that can be combined.
Great, thanks.
So we'll be filing that after the hearing.
So let me just refresh understanding here. Oh, because it's parts 1 and 2, yeah, okay, great. So you'll do an excerpted version, is that the idea? Great. All right, we're good, so.
Judge, are you asking for comments from anyone?
Yes.
So for commission staff, we had seen your comment on the key exhibits. We weren't requiring a refiling, commission's kind of view on the first one, even though we had that page number in there. We would offer to refile it because we realized that there was no NRA disclaimer on the bottom, just like for the RIP key 2, there are actually links embedded in the DNR document. So we'd like to offer a refiling of RIP key 1.
Okay, RIP key 1.
It had a similar issue, it needed the NRA.
Yeah.
And then for Dan Grant's, server bubble is referring to PS reference numbers. In order to identify specific responses to the data request. So what we're gonna do there is, build out some rows in the GRR exhibit to identify the specific items and then just refer to them, and we're gonna use the IRF document description as the name, so it's gonna be a little bit long and wordy, but better than having the PSC reference number. Okay, great. I think that was everything for us. We take all of your notes, and thanks for not, making us refile some of those things that we made errors in.
All right.
Your Honor, I have one more thing. I just got a notice that my witness is actually out of the country, so we would like to call him to the stand to verify his testimony live today instead of filing a verification after the fact.
I see. So is that witness available now?
He is.
All right. Why don't we just take a few of these people, who are just verifying. Do we have, witness counsel just verify? Okay, why don't we call that witness there?
Witness Johnson calls Dr. Karen
Oh, we're on the
Gallagher.
record, yeah. Yeah. And who are we calling? Oh, okay.
I didn't just say. It's on call. Yeah. I'll have her spell her name. What's her name, Jen? I'm sorry. What's her name? Karen Gallagher. Thank you.
You right hand, you swear or affirm, tell the truth, the whole truth, nothing but the truth.
Yes, I do.
You can feel like.
Good morning, Dr. Gallagher. Morning. Please state and spell your name for the record.
Kieran Gallagher, CIARANGALLAGHER.
And are you the same Kieran Gallagher who prepared the direct testimony and 13 exhibits for this proceeding?
Yes, I am.
And if I ask questions in your testimony today, would your answers be the same?
Yes, I would.
Ms. Gallagher is available for cross.
Okay. Any questions? Thanks for your excuse. Who else did we have just for verification?
Your Honor, clarification question. Are you introducing testimony by witness or have you admitted all of the testimony?
Yes, they're all, everything on this offered evidence list is admitted pending verification.
The CEO's call Michael Goggin to stand.
See you there. I'm gonna just spotlight you for the video. Great. So raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
So you're kind of low on your microphone. I don't know if I can do anything about that here. Oh, I know. I moved the table. The reason why I could. That also. Oh. Okay, yeah, I think we heard you say yes, so you're sworn in. Thanks. Go ahead and be your witness.
Good morning, Mr. Goggin. Can you please state and spell your name for the record?
Sure, it's Michael Goggin, and Goggin is Goggin.
Are you the same Michael Goggin who prepared a direct testimony and 9 exhibits for the clean energy organizations in this proceeding?
Yes.
And if you were asked the same questions that were posed in that testimony today, would your answers be the same?
Yes.
Okay, the witness is available for cross.
Any questions?
Yeah, just real briefly. Mr. Goggin, my name is Attorney Eric Olson. I'm here with Chippewa Valley Preservation Alliance. Good to see you today.
Hi.
Can you hear
I can, yes.
well?
I can, yes.
I just had a few quick questions. Are you familiar with the process of transmission line routing in Minnesota?
Not in any detail, no.
No, okay. Would you agree that projects such as the project that's proposed here by the applicants that we're discussing today can displace agricultural operations?
That's not my area of expertise, but it seems intuitive that could be the case in certain situations.
Okay. And is it your area of expertise whether or not projects like the one that's being proposed here today can displace residential occupants, residences, people live places?
That's not my area of expertise.
Okay, so in your evaluation, you didn't consider either of those factors because that's not your area of expertise there.
That's a fair statement.
Okay, thank you. That's all I have.
Other cross? Redirect?
No.
Oh. Okay, thank you, witness Goggin. You're excused.
Thank you.
All right. So, I had failed to address something that I did want to bring up before we got started, and that's I was just curious, this question for you, Attorney Olson. I guess I know that your client is
Chippewa Valley Preservation Alliance.
Chippewa Valley Preservation Alliance. No, and we've seen, I guess my question is, I think we represented to us that it's a nonprofit association. I did some research trying to look at the nature of the organization, and just so I know who is before me, can you give me more of a bigger description of the organization and who it's representing?
Sure. I would say that the fairest way to describe it is a loosely affiliated group of activists formed by Scott Marek. There's no formal membership list, however, there are quite a few members. There's never been anything like a form or anything that anybody fills out to be part of it. However, there have been quite a few people who have been involved to a greater or lesser degree. And there are people who are directly impacted by or opposed to, for one reason or another, Route 2B and the Elk Farm substation option.
And are these people involved in the association of landowners in the project area?
Many are, but some maybe aren't. One in particular was, and I'm just, drawing a little bit of a blank here, but the folks with the animal rescue, does anyone remember what that's called? The name escapes me, but the local animal rescue that does the large animal rescue. I'm not sure that anyone who's involved with that owns any land, but nevertheless, they have the interest in it, and I think Mr. Mark brought that up at some point, either in his direct or in the discovery answers.
Okay, and just roughly how many people are associated with it?
I think I can fairly say certainly more than 10, okay, and I would certainly be happy to do a little bit of Q&A with Mr. Mark when he's on the stand this afternoon to flesh that out. Maybe more than 20.
Okay, yeah, I don't know if, I mean, I don't think for my purposes it's necessary. I think I've heard what I need to hear, but parties can certainly pursue that if they wish, but I think I'm satisfied.
I would expect them to, but
Yeah.
yes.
Oh,
That's what it is. It is what it is, as
Yeah.
I say.
all right, great, thanks. Okay, thanks for that. So, all right, that's all. So anyone else, we just need to verify, so I guess staff is gonna go last, but anyone else, that just needs to verify their testimony live? All right, so let's move on then to the applicant witnesses.
NSPW calls Tony Wenman.
There you go. Come on up. And the LB chair. All right. All the people. All right, let me swear you in. Raise your right hand. You swear or affirm to the truth, the whole truth, nothing but the truth.
Yes.
All right. Go ahead.
Mr. Wenman, would you please describe your role in the project and your position at Excel Energy?
I'm a project director for Excel Energy, and I manage and oversee a group of project managers and the rest of the project team, engineers and project specialists who are responsible for putting together estimates and schedules and executing projects.
Did you prepare and have cause to be filed in this docket direct testimony and rebuttal testimony?
Yes.
If I asked you the questions that are in those testimonies today, would your answers be substantially the same?
Yes.
The witness is available for processing.
All right, so you have questions for the witness who called for questions?
I don't. Mr. Wendland,
Introduce yourself.
my name is attorney. Mr. Wendland, my name is attorney Eric Olson, and I'm here representing the CVPA, the Chippewa Valley Preservation Lines. Is it okay if I ask you a couple questions today?
Yes.
All right. Would it have been your responsibility to determine whether any displacements of people, farms, or businesses would possibly be occurring as a result of this project, or would that have been somebody else's job?
It would have been ultimately my responsibility, but the team that I'm overseeing would have been looking into that, yes.
Okay, and how many people do you think are going to be displaced because of this project?
One that I'm aware of.
Has a relocation plan been prepared?
That's not my area of expertise.
All are you familiar with the requirement under Wisconsin law that anytime that people farm with businesses may be displaced, that typically is required to prepare a relocation plan?
Objection.
Democrat.
This is an area of condemnation and compensation and relocation packages that are beyond scope of this proceeding.
Response?
I asked him a question, opposing what Wisconsin statute 32.25 says is that sub 1 says with certain exceptions, no condom nor may proceed with any activity that may involve the displacement of persons, businesses, business concerns or farm operations until the condemnor has filed in writing a relocation payment plan and relocation assistance service plan and has had both plans approved in writing by the Department of Administration. I was asking him some questions about whether that had been done or not to date. It may not have been. Then that would just be the answer.
Overruled. Answer.
I'm sorry, can you rephrase the question?
Let's read it back.
Questioner, are you familiar with the requirement under Wisconsin law that any time that people, farms, or businesses may have been displaced, that typically it's required to prepare a relocation plan?
I'm aware of that, but not familiar with it.
Would it be fair to say that as we sit here today, you have no knowledge of a relocation plan or a relocation assistance service plan having been prepared in relation to the project that we're considering today?
I don't.
Would you agree that although one person will be displaced by the project that is under consideration unless some change is made to the routing or something is done so that there's not such a close proximity to that person's home, other people, businesses or farms may be displaced by the project that's under consideration today?
Do you mean displaced by that law or by their own will? Like displaced under that law?
Well, what do you understand as being the relevant definition of displaced by a project like this?
I guess if you mean that someone might move because of the proximity under their own will versus it being a requirement of that law. I guess that's what I'm asking.
I'm just asking for your understanding, sir, because I asked before if anyone was going to be displaced because of this project, and you said yes, one resident, one householder, as I understood it. So I'm asking, what is your definition of how did you define displacement?
I guess my understanding is that we're purchasing that home because of the proximity to it.
So would it be fair to state that there is one home on the project as it's currently planned, it may be changed, that your employer agrees is a sufficiently egregious type of an impact that they're undertaking to purchase the home? However, you acknowledge that other people may be caused to move by the project, however, would to some degree be due to their own volitional decisions about how the project impacts their homes, farms, or businesses. Would that be a fair statement of what you've just said?
Yeah, yes.
Oh, that's all I have. Thank you.
Other cross?
If no other interviews, we have some cross for this witness. Good morning, witness number 1. I'm Sophia Rogers for commission staff. So we have two areas that we want to cover with you today, and one is about the EPC bids that you've received. So in your rebuttal, at rebuttal applicants 115, you had stated that NSPW had already sought and received bids for all EPC for this project. So my question is, did you include, or did NSPW include using Wisconsin sourced labor as a criteria?
I'm sorry, did SPW include?
Wisconsin sourced labor as a criteria of its bidding?
Yes, we did. We qualitatively, we looked at that. Also, there were 2 Wisconsin-based companies in the bidding pool.
Is there more that you want to say?
I guess no, but.
Okay. The other question arises from your colleague Naomi Christensen's testimony, but I was directed to ask the question of you, are you able to discuss the 2096 North 75th Avenue property? Okay. So this goes back a ways. I can provide some citations, but at this point, the latest that we've heard from NSPW doesn't explain what's being done currently about the residents. So we just want to find out what the latest update is. Has NSPW determined whether it's possible to move the center line away from that residence as of this time?
We have validated that the current alignment meets the NESC and Wisconsin code. So even with conductor blowout, it's not, the conductors are not over the top of that house.
Okay, so last we had heard, and Judge, could you please pull up the DRR exhibit? We're just gonna pull up the data request response and how you catch us up on where you're at now. Your Honor, would you please go through, it should be the very end of this document, verbal BBR 010125.
Here, which version do you want?
I think.
Here's your issue right here.
Right, exactly. Yeah, we're working on this. I'll have to find it. All right, Josh, I need a moment.
Well, correct.
To be the first one, Your Honor.
7, 8.
Yes.
Get back on the record. You want to identify that for us first.
So in this one, when we're looking at the data request response to PSCW KF VDR 070125. And this is the narrative portion, earth number 554478. Is that right? Or do you recognize this, Stephanie?
Yes.
So in this data request, commission staff had inquired about the property we were just discussing, and the applicants there in response A confirmed that the property was there, and then in C and D, at the bottom of this page, it states that the applicants will first attempt to shift the line to not be within 50 feet of the residence. Can you see that? So is this sorry, I didn't hear a response.
Yes, sorry.
So is this no longer accurate?
We did confirm that we cannot shift the line even further than 50 feet. But we also confirmed that even though it's within 50 feet, it meets the code requirements.
Gotcha. So the second, right there, it says, if it's not possible, the applicants will work with the landowner regarding a negotiation for purchase. Is that still true?
There are a lot of variables to get to that point, but yes, we haven't contacted them yet, but we will.
Okay, you have not had discussions with the landowner?
No.
What kind of timeline are you looking at to have those discussions?
That's a little outside my area of expertise. That would be our siting and land rights agents,
I'm sorry, that would be our,
siting and land rights department. And I guess I'm not prepared to comment on that, right?
Okay, I was directed, but. So, is there another witness who could answer that question today?
Your Honor. Sorry, I was not aware that the timing of the communications was in court. If after a break, I can find somebody who can gather that information and provide it.
Okay, that's fair, thanks.
Thanks very much. That'll work. Thank you, witness.
But just to follow from that last sentence that Attorney Rogers read about negotiating for purchase. Just wanted to clarify, does that mean that the applicant or FPW particular not considering eminent domain for taking that property if necessary? It's going to commit to negotiating a purchase only? You just clarify what we meant, or there's something you need to add.
I guess my understanding of the process would be, we would first offer an easement because we meet code requirements. And then go from there based on what the owner wants. Because if they want to stay there, we're not gonna buy the house, right?
Oh, yeah. So then, no other cross, any redirect?
Yes, Sean. Mr. Wayland, do you have any legal training?
No.
Do you have any understanding of what the term relocation means specifically in the Relocation Act?
No.
Is it true that well, let me ask you a different way, the one landowner where the right of way, the center line is across the property, how close is it to the house?
The one that we're talking about now?
Not the one within 50 feet, the one that you've identified that will need to be removed.
I'm actually not sure.
I'm thinking more questions.
Okay, thanks, your excuse. Who's that?
Mr. Gutzman,
In person or,
Mr. Gutzman, he's actually on video.
Okay, I see you there. Can you hear me okay, Ms. Gibson?
Yes, I can.
Great. So I'll swear you in. Raise your right hand. You swear or affirm, tell the truth, the whole truth, and nothing but the truth.
Yes.
Go ahead.
Thank you. Mr. Gutzman, will you please describe your role in the company and your specific responsibilities of this project?
Yes, I am the transmission planning manager for Xcel Energy, specifically focusing on NSP and NSPW. And my role as the transmission planning manager is to oversee transmission planning analysis studies, whether they be steady state, dynamic, or short circuit, and to provide guidance to the planning engineers in my division as it relates to any transmission planning activities.
Did you prepare a cost to be filed in this docket direct testimony?
Yes.
Do you have any updates to that direct testimony?
Other than the update of my job title has changed since the testimony was filed, there is no updates.
If I asked you those questions today, would your answers be the same?
Yes.
Mr. Gutzman is available for cross.
Okay, we have questions?
You think staff's the only one?
Okay. So let me just screen it then. Okay, go ahead. Very much. Just introduce yourself.
Good morning, witness Gutzman. I'm Sophia Rogers for commission staff. How are you?
I'm good. Thank you.
So we have a couple of questions about GETS, grid enhancing technologies. And I was directed to you, although this arises out of witness Wendland's testimony. Are you familiar with Wendland's rebuttal testimony and its discussion of GETS or its mention of GETS?
I'm familiar.
Thank you. So rebuttal applicants Wendland 6 states that GETS will not be used for this project. Can you elaborate or explain why they won't be used?
So typically GETS or grid enhancing technologies are used on transmission elements in which there is an existing element that needs to be upgraded for a particular purpose, for a particular reason. And we would like to get more capacity out of those existing infrastructures. So this being a brand new potential circuit, we would build the circuit with a future capacity in mind. So that is why to date we don't see the need for grid enhancing technology as a part of this new transmission line. However, we do not rule out the possibility in the future if the need would arise.
So what I just heard, it suggests that the company's current policy is not to use GETS on a new project. Did I hear that correctly?
The company does not have a particular policy related to GETS, no.
But you explained that you might consider it for existing infrastructure and not for a new line.
It could be used for existing infrastructures. That is where it has been used in the past. It is not out of the question that it could be used on a new piece of equipment. However, typically when you plan for a new piece of equipment, you plan with enough capacity in mind. So you don't need to use a GETS necessarily.
Wendland at 6 also stated that NSPW was evaluating and using GETS if suited for a transmission project, which I think is similar to what you just explained. Can you please describe how NSPW evaluates and implements GETS as part of its planning?
So we typically will evaluate gets. Firstly, we look at it on a cost basis. So we look at if there is a transmission element that we need to get extra capacity or efficiency out of that particular element, we will look at gets as one of the solutions to fix that particular problem. For instance, if we have a transmission line which may be thermally limited, we might install a grid enhancing technology like a power flow control device to see if that device may reduce the thermal impact and potentially be a more cost-effective solution than, for instance, reconductoring the transmission circuit. So we utilize gets as a part of our typical planning process. We look at it on a cost basis and then as well as a electrical basis, a physics basis.
No further questions.
Okay, thanks. Other cross? Redirect?
No, Your Honor.
All right. Thank you, witness Gutzman, you're excused.
NSPW calls Naomi Christensen.
Sorry.
Sorry, Your Honor, I missed this one again.
No, you did, yes, I did not do it. I'm just trying to adjust for, this three here. Okay, and, so, raise your right hand, do you swear or affirm, tell the truth, the whole truth, nothing but the truth?
I do.
All right, you're speaking to the microphone.
Ms. Christensen, will you please describe your role in the project and your current position?
Yes, I work for Merchants Incorporated, and that is a firm that has been retained by the company to support the routing efforts. I serve as the project manager at Merchant for this project.
Did you prepare and have cause to be filed, direct testimony, rebuttal testimony, and rebuttal testimony?
Yes.
If I asked you the same questions in that testimony, would your answer be substantially the same?
Yes.
Did you also prepare rebuttal?
Yes.
Can you briefly describe the subject matter of that rebuttal?
Yes, it was a situation where we were responding to a DNR testimony regarding the Halley Marsh Wildlife Area along Route 2.
Your Honor, not sure the SIR was admitted. I would move this time to move the pre-filed. No, it was pre-filed. That one was pre-filed.
Yes.
And SIR rebuttal of Ms. Christensen.
All right, any objections to the SIR rebuttal? No, right, thanks, that's in along with the other testimony from this witness.
No other questions, Your Honor. This witness is available for cross.
All right, who had questions? Olson, go ahead.
Right. Good morning, Ms. Christensen. My name is Eric Olson. I'm here on behalf of the Chippewa Valley Preservation Alliance. Is it okay if I ask you a couple of questions? All right, terrific. So first of all, does the applicant acknowledge that the construction of the Elk Farm substation could cause displacements from residences that are located nearby to the footprint of that substation, that new substation?
I'm not aware of that.
In your opinion, at what point in time does a project of the type that is being proposed by the applicants change the environment to a degree that a person, farm, or business may fairly be said to be displaced? What would be the definition of that in your mind?
Objection, Your Honor. I think it's vague and ambiguous to ask why, this witness, why someone might be displaced, particularly when you don't define displacement. Mr. Olson's used it in a technical term, and he's tried to use it in a voluntary move because someone may not want to be in proximity to the project.
So if you can specify which instance you're referring to, would be better for the record. So yeah, involuntary and voluntary move, you can ask the witness to distinguish that.
Sure. In your filed testimony, Ms. Christensen, you reference a potential for displacement, correct?
Where are you on?
Where it's, I'm trying to pull it up here quick, it's where the response to okay, so on rebuttal applicants Christensen 3 at lines 13 and 14. I guess fairly we could say lines 10 through 14.
Can you keep your voice up a little bit?
Yeah, lines 10 through 14. On line 14.
Let's wait for the witness to get there.
Sure.
You have that page in front of you? Okay. Go ahead.
You say one of the modifications, 190th Street route alternative, would require displacement. What do you mean by the word displacement?
In this case, there is not available right of way along this proposed route.
So the route would have to be displaced?
I believe this is in regards to a route alternative suggested. And this modification, the residence is too close to the road. So therefore the road would not be able to follow the road without displacement.
And then the displacement would mean that that resident would have to go away, right? Move. Correct.
Correct, which is why it is more impactful.
Yes, and so I'm wondering, what are the criteria that you used in your work to determine when a person, business, or farm would be displaced?
We reviewed proximity to residences for each route segment alternative.
So in your opinion, how close can the line that is being proposed here be situated to a residence before that residence, in your opinion, is displaced?
That's not my area of expertise.
Okay. Who would be the person to answer that question?
Possibly Mr. Wendland.
How, in your opinion, how close can the facilities under consideration here today be situated to a farm before that farm operation? And I'll let you discuss different iterations of what that farming might entail, because maybe it's different for dairy and maybe it's different for beef and maybe it's different. How do you determine when that agricultural farm operation is displaced in your mind as you do this work?
also not really my area of expertise.
Whose area of expertise with that?
I'm not aware.
Would it also not be your area of expertise to determine when a business might be displaced by this project?
Correct.
So when you state at rebuttal applicants Christensen 3, lines 10 through 12, yes, as detailed in Mr. Phelps's testimony, NSPW evaluated the 3 modifications proposed by CCLC and concluded that each would increase human and or natural resource impacts. We don't know for a fact, as we sit here today, whether the potential for displacements was considered within that analysis. True.
I believe I did note the one route would require displacement.
Okay. And what were the criteria that you used to determine that one displacement?
Objection asked and answered.
Yeah, I have to agree, that's, I'll sustain that objection.
Okay.
Yeah.
On rebuttal applicants Christensen 5. That's where you were talking about your response to Mr. Marr's concerns. Right.
Edward.
Yes.
Thanks.
At line 4, you state, when more specifically comparing Route 1, and Route 2, Route 1 has more locations where greater slopes occur, parentheses, greater than 20-degree incline. What methodology did you use to make that determination?
I have if that's not my specific area of expertise, but I have a project team members who ran that evaluation.
So that was something that was delegated. It's not something that you can specifically speak to what methodology was used, fair?
That's correct.
At line 7 on the same page, rebuttal applicants Christensen 5. You state Route 1 also occurs within more populated areas where there is an increase in impervious surfaces and generally less forested areas, which can also lead to additional runoff. If the areas, why would that be?
I guess impervious surface, there's more opportunity for runoff. I will say the company will be required to get a construction site stormwater permit, which requires the installation of erosion control sediment devices, so I would say that runoff would be minimized to the extent practical on both
They're both.
routes.
Thank you.
So your point seems to be that Route 1 occurs in more populated areas, correct?
Correct.
And prior to this project taking place, would the impervious surfaces and less forested areas have already existed, or are those going to be created as a result of this project?
That's existing conditions.
And in Route 2, then, would you agree that more forested areas will be cleared because it would be less populated, so they wouldn't already be, for example, parking lots which are impervious surfaces?
I would have to look back at we reviewed a lot of different types of impacts.
So as we sit here today, you don't actually know which route would cause more runoff, true?
As I stated previously, the project would adhere to the construction site stormwater permit, which requires minimization of runoff by the use of the erosion control sediment devices.
That's a requirement in the law in any route that's selected, true?
That's correct.
You state that Route 1 occurs within more populated areas. Do you know whether or not there are any impacts of Route 1 that you can tell us about as we sit here today that would be similar in terms of a change to the environment, like the Elk Farm substation would be?
Objection, vague, and ambiguous.
Cool. Would you agree that the Elk Farm substation would be constructed on a piece of land that's currently just a field, right?
I'd have to look back at the map. And I believe there is a field there.
Okay. As we sit here today, do you know whether there's any existing substation infrastructure where the Elk Farm substation is proposed for this project?
I don't believe so.
So do you know what's around the area that's proposed for the Elk Farm substation? Would it be a neighborhood?
Again, I'd have to look back at the map.
Hypothetically, if there is a neighborhood around the area that is being proposed for the Elk Farm substation, would you agree that some of the residents of that neighborhood may be displaced by having a new neighbor that is a large substation?
Objection, vague as to the term displacement, and the witness has already testified that it's outside of her scope of expertise to identify what necessarily be displaced.
Well, I'll sustain the objection today.
Do you think that some of the do you think it's reasonable for a person who buys a rural residential dwelling to continue living there if a substation is built across the street at the location that's proposed for the Elk Farm substation?
Objection, Ms. Christensen's personal speculation about what would be reasonable is not relevant to the proceeding.
Sustain.
Okay. Ms. Christensen, you wrote and testified on response to routing issues raised. That is the heading of page 2 of your rebuttal testimony. Rebuttal applicants Christensen 2. Correct?
Correct.
Cool. Are you the person who is testifying for the applicants on routing issues, or is somebody else testifying on routing issues?
I'm testifying on routing issues as it relates to routing, but not construction or other site and land rights issues.
Is the human environment part of routing considerations?
Yes,
Does the applicant consider at all the changes that may occur in neighborhoods where people live as the result of their different routes?
proximity to residence is a routing criteria, yes.
Okay. And so I'm asking, in your opinion, is the proximity to the between the proposed elk farm substation and the residences in the neighborhood a close enough proximity that it would be reasonable to expect that some or all of those people may move because of that, if it were effectual like that, in your professional opinion?
Same objection, speculation, as Christensen described, proximity as a count and consideration. Her answer did not lay any further foundation for his question.
You respond?
Well, I think there was sufficient foundation. She's the one who's talking about routing issues. We established that. We established that she considers proximity. We can establish that she considers the human environment as part of her evaluation. And I thought it was a fairly straightforward question, whether they considered that too close or not too close for the people who live in the neighborhood around the proposed elk farm substation.
Ms. Christensen cannot speculate about what neighbors may or may not want to do in proximity to the elk farm substation.
I think if you're planning a route and evaluating routes, there's got to be an element of judgment used, and the people who are doing that planning are going to apply that judgment. So the question is to elicit what the witness in her judgment used and decided in evaluating these routes. It's theirs, going to overrule the objection. Let's read back the question.
Question, so I'm asking, in your opinion, is the proximity to the between the proposed elk farm substation and the residences in the neighborhood a close enough proximity that it would be reasonable to expect that some or all of those people may move because of that, if it were in fact built like that, in your professional opinion?
I can't speak to people's opinions, whether or not they live too close to the elk farm substation.
So if one or more of the people living in proximity to the elk farm substation informed the applicant that they were moving because that route had been selected and that's elk farm substation were going to be built, the applicant would accept that at face value and provide them the relocation services and benefits stipulated under Wisconsin law. Is that your testimony here today?
That's not. Sorry, Mr. Olson is trying to get company commitments out of a consulting witness and moving into condemnation and trying to use voluntary movements as a relocate. I can't even articulate all the reasons that question is improper.
Okay, so in your work, ma'am, how do you determine whether or not a project such as this one may displace people if you don't have any criteria? Do you just base it solely on whether or not a residence is underneath the blown out position of the conductors, which is what I heard for the one, or are there any other criteria?
I would say when we're routing transmission lines, we typically look to ensure that residences do not occur within a proposed right of way width.
So, just to make sure that I'm on the same page with what you're saying. If the residence is within the proposed right of way width, you accept that it is as a displacement, but there's no other criteria.
I think staff objects on the same basis.
No, overruled, that one answer.
Well, as I stated, we want to ensure that homes are not within the right of way when we're looking at routing. If they are, I can't speak to the displacement piece of it. And those homes would be counted and categorized in the application per the application filing requirements.
The question was actually a little bit different, accepting that we look at homes that are actually within the right of way as being possible or maybe even certain displacements depending on the wind displaced condition of the conductors.
I'm sorry, I couldn't hear if you said for displacements. Yeah, there was.
I said, accepting what you just said, that if a home is within the width of the right of way, that may be a displacement in depending on the wind displaced location of the conductors. That's something that you categorize and look at. Are there any other criteria that you look at in considering whether a home, farm, or business may be a displacement?
Not that I can think of.
Are you in your routing work? Are you familiar with the concept of environmental justice?
I'm familiar with the concept, but it's not my area of expertise.
Whose job would it have been in the project that we're here to discuss today to ensure that it adhered to the requirements of environmental justice?
Objection to the form of the question assumes that there's some obligation to evaluate environmental justice.
If you know.
Environmental justice is not a requirement within the application filing requirements.
So to the best of your knowledge, that was not something that was considered in this application.
Correct.
Thank you. That's all my questions.
Any other cross? I just wanted you to clarify, I just noticed something in the testimony that we reviewed, if you wouldn't mind. Actually, the page that Attorney Olson have to about the rebuttal, I believe. Okay. So on page 30 of your rebuttal, we reviewed extensively the question answer regarding the route alternative submitted by Chippewa County Land Conservancy. But I was just curious in terms of the answer of line 10, beginning on line 10. What's stated there is NSPW evaluated the 3 modifications proposed by CCLC. And now you're a third-party consultant for NSPW, is that my understanding right?
Yes.
So in what way was NSPW then doing the evaluation, or were you doing that evaluation in some way? And well, just ask that.
I'm part of the project team, so NSPW and myself as a collective project team conducted that review.
Collective project team, okay. So what I heard is that you really didn't know in terms of the evaluating the modifications and your indication that it would require displacement. You couldn't speak to the details about that. Is that, did I hear that correctly?
when we were reviewing, we asked all as the collective team to review, so, you know, engineering and construction also reviewed those routes and provided feedback.
How many people are on that team?
So it's a lot, isn't?
The best guess.
20.
And different expertise, which expertise were involved, you know?
The engineering, construction, environmental. To be kind of the top three.
And in terms of the displacement issue, who would have been, what expertise would have been most involved in making that?
I believe that was the engineering department.
Anyone in particular that you remember?
And no, I don't recall right now.
All right. Thanks for answering that. Any redirect?
Yes, Your Honor. Ms. Christensen, lots of testimony about displacement. As a routing specialist, would it be accurate to say that when a right of way will be, a home or a building will be in a right of way, that's when you flag it as a potential conflict with the transmission line?
Yes.
And then your client, in this case, NSPW, would do its own evaluation from a technical perspective to determine that building or residence can remain in the right of way without interrupting the safe operation of the line.
That's correct.
No further questions.
Thanks. Hey, you're excused. All right. Well, right, the second. I did want to mention, Commissioner Hawkins, I did want to mention, I did excuse a number of witnesses before you arrived, and I usually make them stay until in case a commissioner comes and asks for questions. So I just wanted to let you know, if you do need to recall anyone, let me know before, and we'll take a break soon, and I can accommodate whatever wishes you have.
My understanding is the commissioner is just observing.
Okay, well, you never know. Okay. And so who do we have left? So maybe time for a quick break. What do you people think? Any objections to that? No? All right, we'll take a half an hour. I'm sorry, any objections? Yeah. No. Take a half an hour, so we'll be back at 12:30. I'm sorry, 12:30, yeah. And we'll start with witness Mark. And then
We have Ashmanston.
We have a couple applicant witnesses. I mean, I'm not sure it makes sense to wait till after that. So we have got,
yeah, I know there's still applicant witnesses, but we can.
I'm sorry, that's
We
fine.
can delay, that's the people overwhelmingly need to, but I thought we'd accommodate Marek at 12:30.
I forgot about that. Sorry.
All right. So I'll be back at 12:30.
In your honor, perhaps, Mr. Donor?
Sure, why don't you talk to the applicants about that?
Okay.
All right, thanks. Yes. Yeah, I don't think that.
Right, so you have-
No, let me go.
Right, the pre-hearing.
Well,
Yeah.
People not gonna
Yeah. So 3 seconds left. So far, it's been great. I mean. Still long.
Yeah.
Oh, nothing.
Okay, so looks like we have Scott, Mark on the line here. Let me just test out your audio. Need to have you on mute. I might be able to help you.
I'm here.
Oh, there we go.
Technology's hard sometimes.
I think I'm gonna try moving the microphone. No, that's right.
Yeah.
It did work out.
I think it was.
It's in like.
It did somehow. Not really sure.
When it's ready for somebody's mouth. I'm kidding.
All right, 12:30, let's get started. Get on the record. So we're gonna call Scott Mark from CVEA. I'll swear you in first, so raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do. Yes.
All right. So that's Attorney Olson's witness, so go ahead, Attorney Olson.
Okay, Mr. Mark, thank you for being here on Zoom. Did you provide direct testimony in this case and 2 exhibits?
I did.
And if I were to ask you those questions that were set forth in that direct testimony here today on the record while you're under oath, would you give those same answers?
Yes.
Were you able to listen into most of the proceedings this morning?
I was. I missed a little bit of the proceedings. However, I did view it via YouTube this morning.
All right. Can you tell us a little bit about what the CVPA is?
So the CVPA is a group of landowners and interested parties that are protecting the environment as well as impacted by the Elk Farm substation and Route 2B. It is a loosely formed group with no formal application process or forms or anything to be in it or leave.
Okay, you formed that group, correct?
I did. We just to add a little bit of context, for the town of Seymour, we deal with the 7 Mile Creek landfill. And in the last decade, there's been other groups similar to this that have formed to, help protect our rights and protect the rights of our neighbors and also protect the environment surrounding it.
Could we commit, if needed, to submitting a group of a list of members within 3 working days who agreed to be identified as members of the CVPA as of that date?
Yes, I could do that.
Now, that was one of the questions that was brought up this morning. The other question had to do with the EIS. Did you hear that word?
I did.
Before you move on.
Yeah.
I'm sorry, guys, before we move on, just because we had a offer of an exhibit, I think, let's just at least nail that down a little bit, so we would mark that, EXCVPA MARC 3. And I think Attorney Olson described it generally, but let me just rephrase maybe for some clarity. So it would be a membership list of the CVPA for members as of the date as of today's date, is that?
I would say more accurately, as of today's date would be fine.
Okay.
Mr. Mark, today's date would be fine. So
Yeah.
in checking with everybody, make sure to ask them if as of the date of this hearing, and then we will submit that list.
Okay, and then just so you know, that'll be a public record on the commission's website, so, I guess I don't have any personal criteria that needs to be on that list, but if, just so you know, in terms of addresses, contact information, that'll appear on our website. So just keep that in mind when you're creating the list.
Correct.
Understood.
Okay. So that'll be filed, can you do that in, you did mention the 3 working days already?
Yes, John.
Oh, 3 working days, in 3 working days, okay, great, thanks.
And then, Mr. Mark, were you present this morning by YouTube when we talked about the issues relating to the EIS, which was Mark 1?
I did. I caught most of it. I did miss the first few minutes of it, but I do understand what the ask was and what the concerns were.
Yeah, I believe it's Mark 2.
Oh, I'm so sorry. Yes. So it would have been EX-CVPA Mark 2. I'd like you to explain to the judge and to the applicant any information you may have about why you would be a person who would be qualified to have any opinion at all about the EIS that had been marked as EX-CVPA Mark 2 to help make a decision about whether you should be allowed to give any opinion about it or not. Go ahead, Mr. Mark.
Definitely. So as a Wisconsin certified master naturalist, as well as spending time working at the Department of Transportation in an area, my desk, actually my cube sits next to all of our environmental folks as well as our surveyors. And then my time at the DNR, I'm a person that asks a lot of questions, get a lot of input. So I do have an understanding of what an EIS is. I know that they have been impactful for other projects outside of transmission line projects. I've lived in this area as well for the last 46 years. When this EIS in the exhibit was brought forward, my family actually lived along the closer in town along the inner option. Our property currently sits adjacent to the spot with our neighbors where the outer option would take place. So I feel that the environmental study that was done of those properties, of the property surrounding that, is specifically Route 2, would be beneficial to at least have a look for this project as well, concerning habitat, concerning endangered species and so on. The land next to us previously was agricultural. It has been put into CRP. This is along proposed Route 2B, and it's been reestablished in prairie and pollinator plantings.
And in that answer, when you were speaking about the inner and the outer options, were those the inner and outer routing options from the EIS that's marked as EX-CVPA Mark 2?
Correct.
With that foundation, I'd like you to explain what limited part of that EX-CVPA Mark 2 you feel would be probative and you'd like this commission to consider.
So specifically, Exhibit 2A, that's in in part 1 of our exhibit. I believe it's noted pages 11-32 and 11-33 locates the specific area where the outer bypass would have gone. And then the associated items that are associated with habitat and endangered resources and the environment itself. I don't have those specifically in front of me.
Okay, but that is something you would be able to isolate from that larger exhibit within the 3 working days that were mandated by the judge in this matter. True?
I believe so.
Oh, there was also the argument that the information that is in EX-CVPA Mark 2 is too old to be of any probative value whatsoever, that it's stale. Speak to that concern, if you would, please.
Yep. So over the last, 35, 40 years, general community involvement in protecting the environment has increased. Knowing my neighbors and knowing what they've done to move to agriculture or move away from agriculture and prohibit the use of herbicides on their family farms and also, on the adjacent property. The focus of our neighborhood, specifically Township of Seymour, and the folks that are involved in CVPA, we're very much in line and very much looking for a better environment and increasing habitat, increasing pollinator plotting, bringing back, restoring prairies. And it really goes back to just, being a good steward of the land.
But so my question was a little bit different. Have you personally observed anything over the intervening time period between when EXCVPA Mark II was created and today's date that would lead you to believe that that information that's in EXCVPA Mark II that is the information we want to present to this commission is still relevant? What have you seen that makes us believe, if anything, that that's still a relevant concern?
Objection. May I speak to it? Mr. Marr hasn't laid any foundation that he is an expert who could know what is in that EIS and be able to study all of the environmental considerations and give us an opinion about whether anything has changed. While he may be able to testify his own experience on what he's observed over time, he's not qualified to tell us if the conditions have changed since the EIS was published.
That's fair. As the answer can be limited to the witness's personal observations, I'll allow it.
Yeah, limiting it to your personal observations, Mr. Mark. Do you understand the question?
Could you repeat it, please?
Yeah. What, if anything, have you seen that makes it a that would lead us to conclude that the concerns expressed in that EIS are still valid concerns as to your neighborhood?
I believe the biggest one is concerning with wild blue lupin, and the blue or the Karner blue butterfly. There is lupin that grows naturally along the roadside along North 65th Avenue. There has been Karner blue butterflies that have been recorded, in this area as well as farther, as well as farther to the east by a significant amount. We are in a Karner blue resource area habitat.
You're going a little too fast for us, sorry.
To the east by a
I'm sorry.
significant amount. Did you say to the east by a significant amount?
No, to the east by a few miles. Significant few miles. I'm sorry, I wasn't real clear with that.
Okay, just please slow down with your statement.
Okay.
Okay.
So there's been a significant sightings, I guess, recordings of the Karner blue within to the east of us. We actually had the biologists from Emergent that were here today who were in the area doing their biological study for this project. And we were talking about the Karner blues, and one of the biologists actually said that, within the last few days or with their studies within the area that she had actually physically seen 4 and reported them as well.
Dr. Pearson?
Noted.
Okay, with that, the witness is available for cross-examination.
All right, great. So cross-examination, start with the applicant.
Thank you, Mr. Matt. I represent Oregon State's Power Company. My name is Lisa Agramonte, and I have a few questions for you this afternoon. Your employment background is in information technology, is that correct?
It is.
And you don't have any education in any of the environmental sciences, is that also correct?
Beyond my certified master naturalist certificate, I do not. Everything else is self-taught, self-learned.
I'd like to revisit the purpose of the CVPA. You mentioned the members of that group being concerned about the nearby waste facility. Is that a purpose for your group?
No, it is not.
And your group was formed solely to oppose Route 2, is that correct?
Route 2B specifically in the Elk Farm substation.
There are no bylaws for this organization, is that also true?
Correct.
And while you have members of the organization, there's been no formal vote or any agreement of those loose knit members that you are speaking on their behalf.
No, there has not.
With respect to Exhibit 2, you had no part in preparing that document, right?
I did not.
How did you come to learn of that at the IS?
Through research, through researching EISs, knowing from past history that the inner and outer bypass would have required an EIS. So I did my research and found it on the internet.
When did you find it, Mr. Mark?
Within the last 2 years.
Yeah.
I have no further questions.
All right, thanks. Any other cross? Redirect?
No.
Okay. All right, thank you, witness Marek, you're excused.
Thank you.
To the chair. Yes.
You had asked me to ask,
Yeah, off the record.
everyone, off the record, yeah. Whether we could, accommodate, Liza witness Don's request to appear, and she graciously said yes, so would that be okay?
That's fine with me. All right, well,
One other thing, while we're off the record.
okay, yeah, oh, off the record.
Yeah,
Yeah.
I have a clarifying question to ask of you with respect to your comment on his direct testimony and your offered evidence list. Your comment pertaining to footnote 4 on page 6 of his testimony. And you indicated that we should refile with the NRE disclaimer after the hyperlink.
Okay.
And I have a question about that.
Okay.
If I may.
So on the testimony.
Yes. Footnote 4 of Donner's testimony.
Yes, there may be a few.
That's page 6.
That, oh, okay. Thought it was gonna be, a first order, which I've
No,
hated about, but okay.
no, this
so-
is actually simpler.
Okay, yeah, that is simpler, okay, good.
No, so here's my question, right? I understand the nature of the comment.
Mhm.
But the reason that we didn't put the NRE note disclaimer notification is because what we're actually citing to here, the NTEP 21 report addendum is part of the record. And so we're wondering whether, for clarifying purposes, it might be better to just eliminate the reference to just eliminate the hyperlink entirely. And then avoid any confusion that there may be two different versions of the same document.
Yeah, that's a great point, and actually what would be required is that you just cite to the exhibit.
Yes.
So I think, if that's part of the application, it would be EX applicants application.
And we've cited to it elsewhere in the testimony.
Okay,
appropriately.
so just cite to it again that way.
So then we would read that, so what I'm proposing, we're just trying to affirm is that it would be a reference for us to just file a revised version of the testimony and eliminate that hyperlink.
And cite to the.
And cite, yes.
And cite to the exhibit, that's all you need to do is cite to the exhibit, and then you, okay, I wouldn't have even noticed.
Right, exactly.
Okay,
I think that would be acceptable to us, prefer it actually.
that's great, I appreciate that.
Okay, so with that,
Yes,
we're ready for Barry.
ready to go, all right, so let's see what we have on the screen here, and we'll get back on the record. So I do have, looks like both the MISO connections are muted, so you need to unmute probably the witness, there we go, so we have Jeremiah Donner there, so I see you, I'm gonna swear you in, so raise your right hand. You swear or affirm, tell the truth, the whole truth, nothing but the truth.
Yes.
All right, great, so it's MISO's witness, go ahead, whoever wants
Okay,
to.
I'll do this portion of it.
Okay.
And Mr. Donner, please state your name and spell it for the record.
My name is Jeremiah Donner. Last name is spelled Doner.
Did you prepare and cause to be filed direct testimony in this case?
Yes.
Do Do you have any clarifications or corrections to your testimony?
No.
And if I were to ask you the same questions in your direct testimony today, would your answers be the same?
Yes.
Okay, the witness is available for cross, Your Honor.
All right, so what questions?
Staff have questions?
Go ahead. Well, let's share the screen here. Introduce yourself.
Yeah, I'm no longer seeing the witness.
Oh, yeah. Oh, yeah. Sorry.
Thanks, Judge. Good morning or good afternoon, witness donor. I'm Sophia Rogers with commission staff. How are you today?
Doing well.
I just have one question for you, and it's about CEII. If we could go to page 23, Your Honor, thank you. Witness donor, could you please explain why this portion of your testimony, why the N1 and N11 contingency conditions do not constitute CEII?
Yes, I can elaborate on that. So the thermal violations described in my testimony refer to facilities that are experiencing overloading as a result of N-1 and N-1 contingencies in the planning analysis and are not elements defined in the contingent event. So in the discussion of the contingencies, my testimony only summarizes the number of contingent events that result in reliability issues, but doesn't provide any further details of that equipment that's involved. And going that next step would be what would be considered CEII. So for that contingency information, the definitions, they do contain detailed equipment names, and that's what we generally consider in our planning analysis, CEII. That information is, provided by our transmission owners who help make that determination. And so MISO in those situations preserves that CEI designation and excludes those details in the material that MISO releases publicly.
No further questions. Thank you, witness donor.
Okay, I did have just a follow-up for you, witness donor. And just what did you mean by, I think you said equipment names, and without giving a name, what exactly, can you just explain what you meant by equipment names being the information that would make this CEII?
So those would be in the contingencies. For example, you can have a contingent event defined where transmission line X is out of service. And so that the name of that element would be X. And so in those events, that more detailed contingency information that identifies those specific transmission elements is what is considered CEII.
Okay, and this may be what led to some of the confusion, because in that bulleted point, can you see the screen share?
Yes, I can.
Can you see? Yeah, so those bulleted points for like the first one says Eau Claire 345-161 kV transformer number 9. So that transformer number 9 is not releasing equipment name that would constitute CEII.
That is correct. So that is naming the element that is overloaded, but it is not giving you that next level of detail of what is the actual contingency. So that N-1 information. So essentially what line is out of service that is causing that overload on that element?
So it's the line that is a particular thing that needs to be kept under wraps.
Correct.
Rather than the transformer.
That is correct.
Okay, are there any other elements to the transmission system that would not be able to be disclosed in a contingency situation like this besides the transmission lines themselves?
So it's really what falls under all of those transmission elements. So it's a transmission line, transformers. It could also, when we look at contingency events, we do look at resources that are out as well. So all of those specific elements that define what a contingency is what we put under that more protective class of CEII information.
Maybe the actual element that's overloaded.
The actual element that is overloaded is not put under that designation of CEII. As you see here in the testimony that I have, which is public testimony, we have not put that under that CEI designation.
Okay, I'm sorry, you're right, I'm confused. It's the element that's causing the overload.
Correct.
Great. Okay. I'll keep learning. Appreciate your patience. Okay.
No problem.
Any other questions for the witness? All right. Thanks very much. You're excused.
Thank you.
Okay, so we have MISO and CVPA covered. Now we can return to the applicants. Who do you want to call?
Applicants call Ms. Ashman. Bring your microphone back.
You can do it. All right. Where you in? You swear or affirm the truth, the whole truth, nothing but the truth.
Yes, I do.
All right. Go ahead.
Good afternoon.
Good afternoon.
What is your role with the company?
My role with the company is a regional vice president of rates and regulatory affairs for NSPW.
How does, what responsibilities do you have with respect to the project?
I am one of a team of many who is working on to receive the permit from the Public Service Commission of Wisconsin and Mr. State.
Did you prepare and cost and file direct and rebuttal testimony?
Yes.
But I asked you the same questions today. Would your answers be substantially as presented in those testimonies?
Yes.
Did you also cause to be prepared and served some sir rebuttal in this case?
Yes.
Briefly describe the content of your sir rebuttal.
Of course, in conjunction with my rebuttal testimony, I provided an exhibit as well that referenced the conditions that various parties have proposed in their direct testimony. In sir rebuttal, numerous parties responded to that, and my sir rebuttal confirms that we have agreement with the commission staff on 3 additional conditions.
At this time, your move admission of the sir rebuttal that was served yesterday.
Any objection? Okay, that's in along with the other testimony from this witness. And I just want to say that I think I overheard commission staff saying they really appreciated that exhibit, so good work.
Ms. Ashman, there was also some questions this morning to Mr. Wendland about discussions with certain landowners. Did you have an opportunity to gather some additional information to respond to staff's questions?
Yes. So my recollection of the discussion this morning with Mr. Wendland concerned a landowner near Elk Farm substation and whether or not that landowner had been contacted by the company. Over the break, I had the opportunity to speak with other representatives from the company and understand that there have been communications with that landowner, but those communications have not been about easement. They have been about survey.
At what point in time would NSP anticipate speaking with the landowner about an easement?
Yeah, it's important to remember that we don't yet have an approved route from the commission or even a CPCN. And so once the commission has approved a route, we will get in touch with that landowner about easements.
Ms. Ashman is available for cross.
Okay, we have questions. I think we have questions. Was it Attorney Olson?
I have some, Your Honor.
Yes.
Right, so good afternoon, Ms. or Attorney Ashton, I should say. And very impressive credentials there, magna cum laude.
Thank you.
Okay, so my first question is are you conversant in Wisconsin's law as it relates to the topic of relocation? Particularly as set forth in section 32.25 of the Wisconsin statutes in regards to relocation payment plan and assistance services?
No, not at all. I spent my entire career as an attorney, as a regulatory attorney.
Okay. Can, as in your position, can you tell us whether or not you are aware, as you sit here today, as to whether the applicants have evaluated whether or not their activity may involve the displacement of persons, business concerns, or farm operations if one or the other of the routes is ultimately approved?
Objection to the extent that the questioner is asking for a legal conclusion, although Ms. Ashman is a trained lawyer, she is acting in a business capacity.
May I ask you to read that?
Yeah, could we read the question back? Because I think it was a fair question.
That's fine. Let's read it back. Just wait on the ruling then.
I believe my objection is based on the fact that Mr. Olson is reading from the statute.
Sorry, my objection is based. I couldn't hear.
Sorry, my objection is based on the fact that while Mr. Olson didn't ask for a legal interpretation, he's reading language from the statute.
Question: in your position, can you tell us whether or not you are aware, as you sit here today, as to whether the applicants have evaluated whether or not their activity may involve the displacement of persons? Displacements of persons, business concerns, or farm operations if one or the other of the routes is ultimately approved?
I'm not aware of any evaluation.
Okay, well, there's pending objection, but I was going to, that's okay. It's gonna overrule, just to the extent that the witness can answer in the business capacity that the witness is in, businesses follow statutes, so we get that testimony all the time, so. Anyway, I think we had our answer.
Can you tell us what procedure, if any, the applicants will be following, assuming one or the other of the routes are approved, to determine which, if any, persons, business concerns, or farm operations are going to be displaced or may be displaced?
I am not aware in my role.
Do you know whose job that would be at one or the other of the applicants submit to figure that, to do that procedure, assuming there is one?
That would be the role of our citing and land rights department.
And is there a particular person who would be in charge of that?
I'm not aware of who's in charge of that process.
Although you're not aware of who is in charge of that process, can you testify in the affirmative that such a process exists, or you're unaware?
May I ask the court reporter to remind me the specific process that we're talking about in the preceding question?
So reading back the question before the last one?
Yeah.
Yeah, sure.
Might need 3 questions. Do you know whose job it would be at one or the other of the applicants to do that procedure, assuming there is one? Answer: that would be the role of our citing and land rights department. Question: is that a particular person who would be in charge of that? Answer: I'm not aware of who's in charge of that process. Question, although you're not aware of who's in charge of that process, can you testify in the affirmative that such a process exists or you're unaware?
I'll interpose an objection. I don't know the process we're talking about.
Well, is there more?
Well,
That's okay. Let's just start over. And I think the process is about just determining whether something is displaced under the statute. If that is not correct, then
No. Do you affirmatively know, as we sit here today, whether one or the other or both of the applicants have a process that they will do once a route is approved, assuming that for the sake of this question that one is, to determine whether persons, business concerns, or farm operations may be displaced as a result of the project?
To the extent any of those are displaced because of the process, the company, both our company, I can't speak for ATC, but NSPW to follow the law. And the process contemplated thereunder.
yeah, I don't think that's what he's asking. He's asking, well, how does NSW determine that a property is eligible under the law?
And I'm not aware of the answer to that question.
And the question was actually slightly different because I think we established that you weren't aware of the answer to that question. My question was, do you know for a fact that an actual process exists at either NSPW or maybe through an outside contractor that's going to be used and followed to determine who, if anybody, may be displaced?
I object for this continued line of questioning. It's outside the scope of the direct, and we're going into details with the witnesses. As already said, doesn't have the knowledge to answer the questions that he's asked.
Well, I think the witness can answer that. Witness doesn't have knowledge, but we haven't gotten that answer yet. But then feel free to do so. If that's the case. It does a process that exists, seems like a fair and pretty limited inquiry. So we'll have an answer for that.
I'm not aware.
Okay.
And would it be fair to say that someone other than yourself would be the person primarily tasked with ensuring that specific type of compliance?
Yes.
Well, and who would that person be?
I'm not certain.
Oh, thank you. That's all my question.
Other cross? Redirect?
No, Your Honor.
Okay. Thanks for excuse. Who's next?
The applicant's called John Glauser.
That's Glauser. Sorry. Swear in, raise your right hand. You swear or affirm to tell the truth, the whole truth, but the truth. I do. You can tip that mic up a little bit. Yeah. Go ahead.
Yeah, my name is Glauser. Can you take your name to the record?
John Glauser. You have time to go by Chris.
Sorry, that's check. Yeah, that's no problem.
Okay, and Mr. Glauser, did you file or cause to be filed direct and rebuttal testimony in this proceeding?
I did.
Do you have any corrections that you'd like to make to your pre-filed testimony?
I would like to make a clarification in my rebuttal testimony.
Can you just point us to the page and line number?
Page 3, line 1.
And what is the nature of the correction?
I would like to change the word materials in the phrase services, comma, as many materials are sourced to services. I would like to do so to better reflect that while ATC has alliance agreements for engineering and construction services, materials are competitively bid typically.
Okay, thank you.
Let me interject for a second. So, any reason why we couldn't have gotten that on our errata by the deadline?
Judge, it was just brought to my attention yesterday.
Okay.
And I'll be honest, I sometimes get a little confused about what's appropriate for errata versus at the hearing. It struck me as something that's simple enough that it would be appropriate to correct today.
Okay, so there really isn't a situation, there's really no criteria to wait for the hearing. So if you do know of a correction before the deadline for errata, it should be in an errata so everyone can see it. There's due process for reviewing that. So written changes to written testimony should be filed in the errata. There's really no provision that says, except for certain things can be corrected at a hearing. I know what happens, and we usually just roll with it, and if you didn't discover it, then you couldn't have given it to us. I get it, but just so we're clear, and whoever is out there listening, the requirements are to file corrections in an errata, and then that's how it should be done. So go ahead, thanks.
Yeah, understood. Thank you, Judge. Mr. Glauser, with that correction, if I asked you the same questions in your pre-filed direct and rebuttal today, would your answer be the same?
Yes.
And is your pre-filed testimony true and correct to the best of your knowledge?
It is.
Okay, I do want to ask you one question about the surrebuttal testimony filed by Commission Staff Witness Kyle Feltus. Did you review that testimony?
I did.
And you're aware that Mr. Feltus proposed a revised order condition concerning vegetative screening around the Jump River substation?
I am.
And can you tell the commission, does ATC object to that proposed condition?
No.
With that, Your Honor, the witness is available for cross.
Okay, are there questions? Attorney Olson, just have one, we'll have the interviewer go first.
Yeah, okay. Is it Glauser?
Glauser.
Glauser. Good afternoon, Mr. Glauser. My name is Attorney Art Olson, and I'm here on behalf of the CVPA. I just have one question for you. Do you know if there are any guidelines or criteria as to how far away from human habitations a substation should ideally be sited?
I am not aware of such a specific number.
Okay, thank you.
Any other interveners? Check, okay, go ahead.
Off the if we can go off the record and just hear back, what the edit was to that written testimony.
Oh, yeah, sure, go ahead.
Sorry, I gotta ask you a question.
Off the record. So-
Perhaps the way to just repeat what the,
Yeah, I can,
yeah, that'd be great.
yeah, I'll just, it's on,
Are you?
Off the record. Thanks.
it's on his rebuttal testimony, page 3, line 1,
Right,
replacing the word materials with services.
and then there was no other addition,
That was it.
but he clarified that services are,
Well, I'll let.
He did say services are.
Engineering
No.
and construction services are not competitively bid typically, but construction materials are.
the materials, some services are not.
And that's already on. That was already stated on the record, so we're.
Right,
Yeah.
yes. Okay, so I think we do have just one question.
Sure, okay, put that on the record.
Good afternoon, witness Clauser and Sophia Rogers of the train staff with commission staff. And so I think my question is just about services, which you said are sourced based on negotiated rates.
Correct.
Can you explain how ATC selects the firm that it wants to negotiate those rates with, if there are multiple firms, or how those firms are chosen?
As far as onboarding, I can't speak to that process, no. So I'm not able to speak to how those are onboarded initially.
Are you aware of whether there are multiple firms that are negotiated with? I'm sorry, that's part of your answer already.
ATC does work with multiple firms and does have negotiated rates with multiple engineering partners and multiple construction contractors.
So is it fair to say that when negotiating a rate with one firm, ATC is negotiating one against the other, looking at multiple firms for the same service?
I'm not intimately involved in the analysis of those rates.
Well, I'm not really asking for much here, just if there are multiple firms that are being consulted, and so do you know if there's multiple firms that ATC is going to for the same thing?
I'm not intimately involved in looking at those, but to my knowledge, yes, ATC does consider past, I guess, rates from the various vendors.
Did you say past rates?
I meant to say past, I was going at past projects, past performance, looking at comparing rates from multiple vendors in our past projects with them.
Okay, but when faced with the decision, is ATC just going to one vendor and negotiating with them directly? And not, I think you've already explained this. I think you said it's just one vendor at a time that ATC is going to, right?
For a specific project,
Yes.
ATC would select a vendor at the outset of the project.
Okay.
To better leverage them in the project planning process and use more efficient execution.
So then can you explain how the negotiation would work if they've already been selected?
I can't speak to how the negotiation works.
Is there anyone appearing today that could speak to that?
Not that I'm aware of, not appearing today.
Okay, it sounds like you're saying that I'm just struggling to see how the negotiation could be effective. Can you maybe offer anything for the record to explain why that's a competitive rate?
ATC does compare the rates between our vendors. I guess I can't speak to the mechanics of how that comparison is applied and used in negotiations.
Okay, so there is a comparison. You said there is a comparison of the rates, and presumably ATC is choosing a lower rate in that initial decision, and then going to the vendor is selected.
I would say ATC is not assigning the project on a rate basis. ATC retains our consultants and contractors. And we employ them on multiple projects at the same time. And look to gain efficiencies. I guess get the best value out of those deals by including them in the project planning process to eliminate duplication of work. That would be the entail if we competitively bid each project. We also get continuity by employing the same consultants, the same staff from project to project. Becoming more familiar with our standards, executing projects more efficiently in that regard.
That all makes sense. I can see that benefit, but is there any check on the rates that they're charging ATC?
ATC does have various stage gates during our project.
Various.
Stage gates.
Thank you.
During our project process, in which costs are reviewed prior to advancing to the next stage of the project.
Can you tell me what a stage gate is? I don't know that too.
At a particular stage of the project, such as before advancing to construction. The project planning to date would be reviewed along with estimated costs.
At that point, is there opportunity to curb vendor costs by negotiating with the vendor?
I'm not sure if we would do it. I can't speak to what would happen in terms of negotiated rates. I would offer that that is an opportunity for ATC to address with our vendors. Address whether their estimated costs align with our benchmarks or expectations.
So would reimbursements ever change? Would reimbursements ever change based on a discussion at that point?
I'm not aware of reimbursements happening at that point.
Or payable expenses, is there an opportunity for ATC to recoup any costs? If it feels that they're over estimates at that stage gate?
I guess I'm gonna object here. I don't know, the witness has kind of said already that they're not intimately familiar with how these rates are negotiated. I don't know that the witness has the foundation to answer these detailed questions.
Okay, well, you can let us know. None of us do apparently, so let's see what we can find out.
Can you repeat your question, please?
Let's read it back.
Question, is there an opportunity for ATC to recoup any costs in the fields of their overestimates at that change gate?
I don't think I said, I'm not sure what I had said. May I rephrase, because I don't think that's quite.
Sure. Go ahead.
If ATC at a stage gate takes a look at costs that have been accruing and is not happy with the costs, they're over their expectation. What happens next?
In my role as a substation engineer, I would be escalating that on my leadership chain. The particular mechanics, I'm not aware of the specific mechanics.
Okay, and in your understanding, and if it's beyond it, just let me know. In your understanding, would ATC potentially stop going back to that vendor if they weren't happy with the costs that they were accruing?
That's a little bit above my level. I'm not able to answer that specifically.
Okay, I don't think I have any further questions, for this witness, but if there's another witness that can perhaps speak to this.
I don't I mean, I can check during the break. I don't know that we have anyone on hand that can speak to these specific questions. But we can check.
That would be helpful, yeah, I mean, this is the witness who would, address competitive costs, in testimony, so that's why we're directing the questions to you in this, clauser, but, I think if we can get a little more clarity, that would be helpful.
Yeah, we can look into it, but again, I don't know who is available today at this time to answer these specifics. I think, Mr. Glauser is testifying based on his personal knowledge and the order condition that staff had, proposed, so.
Nothing further.
So I did have one clarifying follow-up, whatever we want to call it, question. You just mentioned that if there was an escalated cost that you had concern with, you escalated to management or a higher level to evaluate. So in your experience have you actually done that in the past?
I have.
In your experience, what was the result of bringing it up?
I would say I've seen instances where say we're at a stage gauge or thereabouts, and a request for additional funding was requested due to the purchase order being exhausted, and that may not be granted in those instances. The project will still be completed.
And so no additional funds would be provided to the vendor?
Correct.
And can you give us a rough estimate how many times you think that's happened in your experience?
In my experience, I don't have an exact number. Like 5, not a common occurrence, but it has happened.
In your experience, how many times have over a higher than expected cost been approved by the team that makes that decision?
I guess I would say that it happens, should preface that, right? If there is a change order proposed, ATC does require some rationale for approving that. We do require some sort of explanation of the extenuating circumstances or scope change that's driving that change.
And what would be like?
Not sure I could give you a very good number. It's 2 dozen perhaps.
So is there a procedure, a policy, or a guide in writing that kind of describes this process?
We do have a process that we go through where a consultant or a contractor would identify a change and request additional funding. Kick off early.
It's a written document.
Yes.
All right, and just how many, so when you're giving those numbers, are you talking specifically about substation projects?
Yes, sir, in my personal experience.
So how many substation projects have you worked on?
I don't have the number off the top of my head. It means 50, 60 perhaps. Okay.
Just want to get a context. Okay. All right, any other thoughts? Indra?
I would like to do some brief redirect.
Yes.
So Mr. Glauser, we're having this discussion about ATC's bidding practices. And you made the initial correction that you made to your rebuttal testimony was that to say that construction and engineering services are sourced based on negotiated rates, right?
Correct.
Does ATC refer to those services as alliance partnerships?
Yes, they do.
Can you just explain for the commission what an alliance partnership is?
Sure. So an alliance partnership is a long-term strategic contract. Multiple firms that ETC employs. We employ the same teams across the footprint, multiple projects simultaneously and over the years. We engage these teams at the outset of projects and keep them on for the duration to improve efficiency on the planning side, improve the outcome of the project in that sense. We keep these teams employed across the footprint on various projects such that they become more familiar with our processes, standards, so they can execute our projects more efficiently. It helps keep our construction contractors on the footprint and available for emergencies and for maintenance.
And these alliance partnerships are specific to construction services and engineering services, is that correct?
Yes.
And for construction materials, does the company generally bid those competitively?
Yes, generally speaking, ETC competitively bids materials.
Are you generally familiar with how ATC has performed in terms of cost management on its projects over the last 5 to 10 years?
At a very high level.
Is it your understanding that ATC has generally been able to construct its projects at or under budget?
Generally speaking, yes.
And that's all I have.
Okay, great. So I did hear the witness say that there is a guide document that deals with well, at least the escalation process, but I think it would be valuable if we could have on the record the document, if there's a document involved in this alliance partnership and how it works with the in terms of the practices of ATC and its procedures for partnering with service industries. So is that a document we can?
Judge, we can look into it, but that is gonna be some highly competitively sensitive information. I understand the commission has a practice of, you know, wanting to limit redaction so that the public has access to information, but I would venture to say that probably that entire document we are gonna claim is confidential, and I think in light of Mr. Glauser's testimony today, I don't know that it's needed for the record. I don't know that it's gonna benefit the record to have it in light of the testimony, so.
Okay. Well, I think it's useful to have it in the record, so file it, and you can file this with the confidentiality that you would wish to claim. Staff can review that, so that'll be Glauser 1. And so, I mean, we may need to get someone to verify. Sounds like ETC is stating that something along those lines exists, so it just takes the alliance partnership program. There's a document that describes or delineates the elements of that program. That's work. Is that something that you know we have?
Yeah, I mean, again, sitting here, I don't know. We can look into it and report back. There may not be.
Well, let me just ask, the witness knows there's some overarching document that deals with the alliance.
That, I guess I was not trying to speak to that.
Right, I understand. You're
I'm
not.
not aware of that,
Okay.
sure.
So let's at least get the cost overrun document. So let's make the cost overrun document Glauser 2. And then for the alliance partnership document, the Glauser 1, you can report back to its existence or non-existence.
Judge, I think, sorry, just, I think that the cost escalation document we're talking about would basically be a chain procedure for change orders.
Okay, if does that make sense to you?
That's what I was thinking.
Okay.
Yes.
Yeah, I don't, we have anything else with this witness?
Okay, great. All right, thanks for your piece. Adjust my notes. It's gonna find its own way, it's all, yeah, it's AI doing its thing.
Don't say that.
All right. So get back on the record, who's notes? Do we have anyone?
Your Honor, the applicants have presented their witnesses.
Perfect, all right, thanks. So I know we had felt this and in terms of testifying, and then the other witness for staff would be just verifying stuff.
That's right, Your Honor. We take a quick break so I can consult with the applicants, counsel to see if there's anything more we can do to clarify cost control measures.
Okay, do 15 minutes?
Thank
All right,
you.
thanks, so, reading that right, 2:50, we'll be back.
Thanks.
1:50, yeah. Not reading that right. I'm reading that right. Working got excited. We'll get started with staff witnesses.
We can start with, Kyle Feltus, Commission staff calls Kyle Feltus to the stand.
Raise your right hand, do you swear or affirm the truth, whole truth, nothing but the truth? Yes, I do. So, go ahead.
After you witness Feltus, did you prepare and file or cause to be filed direct rebuttal and rebuttal testimony in this case?
Yes, I did.
And are you also sponsoring the FEIS exhibit?
Yes, I am.
And are the statements and representations in the testimony and exhibits you filed in this case true and correct?
Yes.
Do you have any additions or modifications to your testimony or exhibits?
No.
Open to cross.
Okay, there's indicated that there already said questions. Is that Attorney Olson? Yes.
Okay. Good afternoon, Mr. It's Feltus, right?
Feltus, yes.
Yeah, good afternoon, Mr. Feltus. My name is Attorney Eric Olson. I'm here with CDPA. Is it okay if I ask a few questions? Right. What criteria does the what criteria do you use, if any, to determine when a residence is too close to a facility of the type that's being proposed in this docket, to the extent that you flag it as being a relocation?
Commission staff doesn't determine whether a residence is relocated.
Is it the job of the applicant to make that determination?
Yes.
That's all I have. Thank you.
Okay, other cross? Redirect?
No, Your Honor.
Thanks very much. Your excuse. All right. So we'll be taking the other staff witnesses live.
Yeah, let's do everybody in person. Let's go with Jim Tricka next.
I'm sorry, what's that?
Jim Tricka, TRCKA.
His right hand, he's for our front, tell the truth, the whole truth, nothing but the truth.
I do.
Witness Tricka, did you prepare and file or cause to be filed direct and rebuttal testimony in this docket?
I did.
Are the statements and representations in the testimony you filed true and correct?
Yeah.
Do you have any additions or modifications at this time?
Yes, I will be providing an exhibit, the final decision for Badger Cooley, former transmission projects. In my survey, I referenced an order point in the final decision, and it is no longer available on, public facing earth.
Judge, I neglected to mention it this morning, but we sent a notification by 1:30 yesterday with a copy of that, and it's a 2015 decision. It's just not on the public website.
Okay, now I'm feeling old. Probably all because I didn't think that would happen that soon.
It's
Okay.
nothing personal.
I know, right? Well, it's 10 years after the dockets closed. Okay, so it's not too bad. Yes, okay, so that'll be Tricka 1. The Badger Cooley final decision.
Thank you, Your Honor. And witness Tricka is what you're planning to file, as EX Tricka 1, a true and correct copy of that Badger Cooley final decision.
It is.
Do you have any corrections, to the FEIS at this time?
I do have a correction, in table 6.5, under section 6.1.2, proposed right of way. There are 4 numbers. I'd like to correct in the row 2A with Trumbull substation expansion north. Should I read them?
Yes, please.
Under existing right of way shared, instead of 76.1, should be 477.3. Under new right of way, instead of 666.1, it should be 228.1. Under total right of way, instead of 742.2, it should be 705.3. And under percentage of shared right of way, instead of 10%, it should be 68%. And because this was copied under table 7.3 or 7-3, the same information there should also be corrected.
No further, questions for direct judge. We'd like to move, to admit the document identified as TRICA 1, into evidence at this time.
Okay, so, so we've marked TRICA 1, which is expected
Okay,
in 3 days. I don't think there's gonna be any controversy with receiving that, as long as it's what we expect to see. Can you just review just what were the tables on the FBIS that need to be modified? Just list out the numbers.
Yeah, table 6.5. It should be, or,
Just the number of the table. That's all.
oh yeah, table 6.5 and table 7.3.
Oh, thanks.
Which, which appendix was that?
So let's go off the record. So it's actually on the main document. It's page 186 is table 6.5. And page 256 is 7.3.
That's the 550885.
Yes. Okay, back on the record. So to be fair, I'm gonna ask staff, was this identified for the errata deadline? And if so, why wasn't it corrected?
It was identified, but it's not a correction to testimony or exhibits. The deadline for errata for the FBIS passed 30 days ago. As far as we understand the law, so we had to get the FBIS issued 30 days ago. The only errata that we saw historically was issued in time for the 30-day deadline. So we thought doing it this way made sense. It might make more sense for us to file an exhibit, you know, with a strike through of these two tables. We can do that, but it's pretty inconsequential. And I can ask witness Strickland to explain the significance of it.
No, that's okay. I guess what I would expect to see is that if you know that there's a correction to an exhibit, that it's refiled within the errata deadline period. So
Okay,
that could be different than the FBIS, because this is an FBIS, I understand this could be a little tricky.
yeah,
But if the comment period for the FBIS was
it's
closed,
not it's the FBIS has to be posted 30 days before the hearing.
yeah, yes, it's fine. So,
Okay.
but the new version could have been filed earlier once the correction was
Okay.
discovered.
Okay, understood. You would have preferred to see an actual correction in the FBIS.
Just a new version. Just the corrected, and the version
Corrected
with the
version.
correction.
Corrected version of FBIS and then a revised exhibit linking to that. Would you like to see that still, or are we past?
Oh, no, we need it. Yeah.
Okay, so we'll correct the FBIS.
Yeah.
Just the corrected version, no errata.
That's right. Yeah, at this point. Yeah.
Okay, and then we'll have a revised EX PSC FBIS updated. Okay.
Yeah.
Thanks, Aaron.
And it just wasn't, yeah, so misunderstood.
My confusion.
Yeah, that's right. Okay, so anything else?
Nothing from staff.
Any questions? Nothing? All right, you're excused, thanks. Who's next?
Let's take Paul Ron. On our scene.
Brian, do you swear or affirm to tell the truth, the whole truth, and I do. No, go ahead.
Good afternoon, witness Ron. Did you prepare and file or cause to be filed direct testimony in this case?
Yes.
Are the statements and representations in the testimony filed true and correct?
Yes.
Do you have any additions or modifications to your testimony at this time?
No.
No further questions, open to cross.
Any questions? You're excused, thanks.
Commission staff calls Bill Coble to the stand.
If I hand, you swear or affirm to tell the truth, the whole truth, and nothing but the truth. I do. Give it to the mic. I do.
Good afternoon, witness Coble. Did you file and cause to be filed direct testimony and an exhibit in this case?
Yes.
And are the statements and representations in the testimony and exhibit you filed in this case true and correct?
Yes.
Do you have any additions or modifications at this time?
I do not.
No further questions.
Any questions? Thanks, you're excused.
Commission staff calls Bert Shee to the stand.
Are you in? Swear or affirm, tell the truth, the whole truth, nothing but the truth?
I do.
All right.
Good afternoon, witness Shee. Did you, actually, I'm sorry. This is a special one. So we did give the parties notice of the substitution in advance. Witness Shee, could you start, by just explaining what is your position in the Public Service Commission of Wisconsin?
Yes, I'm an engineering supervisor with the Division of Energy Regulation and Policies.
Please describe your professional training and expertise.
I have a bachelor's degree in electrical engineering from the University of Maryland. I have over 10 years of experience working in the electric utility industry as an engineer. And I have been employed by the commission as an engineer since 2020. I've been in my current position since December of 2024. At the commission, I've reviewed and performed the engineering analyses for transmission construction dockets, including 137 CE 195, 137 CE 209, and 4220 CE 183.
What has been your role in this docket?
I was Colton Bushy's supervisor. Mr. Bushy was a former witness in this docket and one of the commission staff engineers assigned in this case. I took over this docket. We departed from the commission on July 7th of 2025. As Mr. Bushy's direct supervisor, I have reviewed his work in this docket, and I've also independently reviewed the application that requests responses.
Okay, and did Mr. Witness Bushy prepare and file or cause to be filed direct testimony and one exhibit in this case?
Yes, he did.
And in your professional opinion, are the statements and representations in his testimony and the exhibit true and correct?
Yes, they are.
Do you have any additions or modifications at this time?
No, I do not.
Okay, no further questions.
All right. Any questions for the witness? You're excused, thanks.
Thank you.
Commission staff calls Dan Grant to the stand.
Careful, careful. So many wires here.
All done.
Got you here, safe and sound. Raise your right hand. Swear or affirm the truth, the whole truth, nothing but the truth.
Yes.
So, go ahead.
Good afternoon, Dr. Grant.
Good afternoon.
Did you prepare and file or cause to be filed direct and certifiable testimony in this case?
Yes, I did.
And are the statements and representations in your testimonies true and correct?
Yes, they are.
Do you have any additions or modifications at this time? No further questions.
Any questions? Yeah, thanks for excused. Go around, you say.
Okay, two more in person. Stacy, Commission staff calls, do you know if Stacy Grove?
Right hand, you swear or affirm the truth, the whole truth, nothing but the truth.
I do.
All right, go ahead.
Good afternoon, witness Earl. Did you prepare and file or custody file the direct testimony in this case?
Yes, I did.
And are the statements and representations in your testimony true and correct?
Yes, they are.
Do you have any additions or modifications at this time?
I do not.
No further questions.
Any questions for the witness? Thanks very much, you're excused.
Commission staff calls us, Wes Matthews to the stand.
And swear or affirm the whole truth, nothing but the truth.
Yes, I do.
Good afternoon, witness Matthews. Did you prepare and file or cause to be filed direct and rebuttal testimonies in this case?
Yes, I did.
And are the statements, in your testimonies true and accurate?
Yes, they are.
Did you review the rebuttal applicants Christensen did you review, the rebuttal applicants Christensen filing?
Yes, I did.
Okay, do you have any, clarifications or comments on that?
I do. Yep. It, as I understand it, with regards to that source or rebuttal, there appears to be a distinction between the right of way and the DNR publicly owned lands. That being the Hallie Marsh State Wildlife Area. With an assertion that the DNR does not own that road right of way. At this time, I do not know who owns that road right of way in fee title. That process and coordination would occur at a later stage pending commission approval and route selection, as well as with the appropriate DNR program, that being DNR real estate program. And I would just add at this time, I don't have any concerns that the applicants would follow through on that coordination and process.
Do you have any, anything else, to add or modify to your testimony?
No, I do not.
No further questions, open to cross.
Any questions? No, all right, thanks very much.
Okay, anybody else in person witness? Okay, let's move on. We can go on our witness, Beefeld, from DACA.
There you are. Right, okay, let me swear you in, raise your right hand. Swear or affirm, tell the truth, the whole truth, nothing but the truth.
I do.
All right, go ahead.
Good afternoon, witness Beefeld. Did you prepare and file or custody filed, if you can scroll up your.
Yes, something else.
I think it was direct, and when I said it, AIS exhibit, let's see if there's anything else.
The AIS.
Oh, okay, and then also Beefeld one, did you file, did you prepare and file, custody filed, direct and two exhibits in this case?
Yes.
And actually, since it's unusual, witness Beefeld, do you mind explaining what the purpose of DACA Beefeld one is?
Yes, that is to include the project initiator feedback form. As before we publish an AIS, we allow the project initiators, the applicants in this case, to review the AIS and provide any comments. And I included that to attach those. Typically in projects, we include that as an appendix, but we had not in this case. So I wanted to make sure it was in the record.
Thank you. So are the statements and representations in your testimony and in those exhibits true and correct?
Yes.
Do you have any additions or modifications at this time?
I do not.
No further questions.
All right, any questions, cross questions? Okay, all right, all right, thanks, you're excused.
Thank you.
All right.
You're not gonna see that, so we did take Paul Ron. Or,
Oh, yeah, you're right.
I think we did, witness Renier, his testimony was adopted by Kyle Beltis, and I failed to.
Okay.
Maybe we can recall
We'll
him.
need to recall.
I'm sorry, Kyle.
So you recall you're under oath? I think it's.
Yes.
Okay.
Witness Beltis, are you, adopting the direct testimony of Kenneth Renier, or running, I'm not sure his name.
Yes, I am.
Okay, and are the statements and, representations in that testimony true and correct to the best of your knowledge?
Yes.
You already, made one minor modification in your rebuttal testimony, but are there any other modifications that you wish to make to that direct testimony?
No, no other modification.
Okay, thank you, and I'm now really fun.
The so. Well, there's no objections to this, so I'll just leave it the way it is.
Is there an issue with?
No, I mean, we could ask this if he's reviewed. It's fine, don't worry about it. And so
I think he, in his rebuttal, said.
already
Yes.
adopted, okay.
Yes.
Okay, so so is he available for process?
He's available
Testimony,
for
okay,
process.
so any
Okay.
questions related to the Renier testimony? Okay.
I have just.
Oh, yeah.
Very briefly, my name is Eric Olson, I'm here with the CBPA, we just had a question and answer a moment ago. On page 3 of direct Renier, there was the statement about, it was saying that along Route 1 with potential adverse impacts to wildlife habitat and users' aesthetic experiences. I just wanted to ask you if you were aware of any methodology or procedure that was used to quantify the impacts to aesthetic experiences for Route 1 or Route 2?
No, there's no way to quantify that impact. It's just a qualitative aesthetic impact.
Okay, but there could also be a procedure of some sort to try to qualitatively analyze the impact from various viewpoints that might reasonably occur throughout Route 1 and Route 2. Did anything like that occur to the best of your knowledge as we sit here today?
Hypothetically speaking, yes, that could be possible through like photo simulations of project infrastructure in those locations shown before and after. I recall there are photo simulations in the application.
There are certainly some in the record. I was wondering if you knew whether that had been done in a methodological way, I suppose would be the word, for all of the receptors, or however we term that, in other words, was some sort of an overarching methodology employed to say from an aesthetic impact standpoint, one or the other of the routes was more impactful than the other, if you know if something like that was done or not.
The methodology would have been employed by the applicants when preparing the application.
So you're not aware of whether that happened?
I'm not aware of exactly the criteria they used, but I believe they had done so in a way where certain landmarks of the project that could be viewed as more impactful were included.
Would your that answer that you just gave have been based on reviewing the application materials that are in the docket?
Yes.
Okay, thank you.
All right, under cross. Rewrite.
No, you're right.
Okay, thanks very much. Now you're.
Commission staff calls Andrew Kraft to the stand. He's online.
Look at him, he's right there. Okay. All right, so swear you in, raise your right hand, you swear or affirm the truth, whole truth, and nothing but the truth.
Yes, I do.
Perfect. Okay, go ahead and turn your round.
Good afternoon, witness Kraft. Did you file or cause to be filed direct against Kraft?
Yes,
And are the statements and representations in the testimony that you filed true and correct?
yes, they are.
Do you have any additions or modifications at this time?
No, I do not.
No further questions, Your Honor.
Any questions from the parties? All right, oh, actually, I thought I do, okay, we're fine.
So, are you aware of any sort of analysis that was done from the standpoint of, which of the routes that are being, I'm sorry, I'm got ahead of myself here. My name is Eric Olson and, I'm here with the CVPA. Good afternoon, sir. Is it okay if I ask you a couple of questions?
Yes.
I'm just wondering because in your educational and professional background and experience, you have quite an impressive background here. And I was just wondering if your analysis was related more to the archaeological or historical aspects of the proposed routes, or would you have also been involved in reviewing the current sociocultural impacts of
the current.
sociocultural impacts, I suppose you could say. In other words, which of the routes would be more impactful to people living in neighborhoods now on one or the other of the routes?
Objection to that question. It's stated in his testimony what the scope of witness past review is, and it's clearly not reviewing current socioeconomic or that question is answered clearly in his testimony. We didn't get notification across the beginning of today's hearing, so I don't think this is under questions, but witness Kraft on the spot and answering.
Okay, well, I will accept that as that not something that.
Correct, yes.
Okay, thank you.
Other cross? No redirect.
No redirect.
So thanks very much, you're excused.
Commission staff calls Mark Ripke to the stand.
Okay, I see you there. Raise your right hand. You swear or affirm tell the truth, the whole truth, nothing but the truth.
Yes.
Okay, go ahead.
Witness Ripke, good afternoon. Did you prepare and file or cause to be filed? I see, okay, direct errata and 2 exhibits in this case.
Yes, I did.
And are the statements and representations in your testimony and exhibits true and correct?
Yes, they are.
Do you have any additions or modifications at this time?
No, I do not.
No further questions.
Any questions for the witness? No, you're excused, thanks. It's not very good training for these guys. We're alone. Well, look at that.
Great.
That's it. That's all of our staff witnesses, and that's all the witnesses we have. So I think at this point we were done taking testimony. We've reviewed documents that we're looking forward to getting on our scheduled timeframe. So we have the post hearing schedule already set. Is there anything else we need to address before we adjourn?
I don't think so. We can at the break, and ATC can provide some form of a cost. And we had already determined those 2 exhibits. I'm a little wary of the first exhibit coming in and then being like redacted and having that debate over that confidential handling determination. I think the second exhibit is more important. But if you're, order to require the first one, I'm just anticipating a bit of a difficulty in, the confidential line for that, line is partnership. If we could live with the second one alone, that'd be easier.
Well, I guess I don't know until we see it, so I do want it filed, but what I'd say is, I mean, I think. Just from a reasonable standpoint, there's gotta be some words in the document that are confidential, so to the extent that we can have. Headings or, you know, and is, may not be confidential, but, so. You know, I understand that this may actually be, it actually deals with a competitive nature of a business, you're talking about procuring, services, so. But, I think the kind of the gut check is we can't accept a document that's completely redacted as the public version. That doesn't mean that there isn't a rationale and a reasonable way to redact the documents in a substantial way, so that.
Okay.
So I think we could see it and, and saying that I don't want the debate about confidentiality, the claim and the process of proving its delay. The record as it moves forward, so, I'm not really expecting a lot of controversy here, just do a best efforts to give us something for the public, but. Just so they know, like. They have something to look at, rather than totally black pages, so that would probably do, in this instance, so, but having said that, I think I would like to get both that.
Understood, Judge, we will, we'll look into, I just want to clarify that it is, I think it is, there are gonna be heavy redactions on both of them, but we will be reasonable and will be justified.
Okay, perfect, and, yeah, and so, I know we've discussed this. In a few dockets here, but, and I think ATC usually files an affidavit, so there's plenty of room there to just give us your full explanation of why it's, you know, the justification. We can have that, we can rely on it, that's good. You know, simple regurgitation of the standard is not gonna work in any case, even though the redactions make sense, I need the justification provided, according to our, PSC two.
And one more note is that, we can look forward to some testimony in the next docket, which is, much more substantially ATC, that we can keep working on this issue.
Understood, yeah, thanks. All right, anything else? Great, we're adjourned, thanks.
Thank you.
Giving you 2 days of your life.
Yeah. You too.